Good morning, Attorney Holly. Could you look in the chat?
Good morning, everyone. Hope everyone's well this morning.
Good morning, Judge. Good morning.
Morning, Judge.
Good morning, Your Honor.
Morning.
Morning, Your Honor.
Good morning, everyone. Let's see, where are we starting this morning?
We had courtroom 2, position 2, Mr. Boatwright.
This is a negotiated plea, is that correct?
That's correct.
Good morning, Mr. Boatwright. I'm Judge Eric Moore. This is the state all-purpose calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
I don't even know if the COVID-19 is still going on, but he just gave me a mad for the virus.
My question was, we're doing this by video. Do you agree to have your case
Yeah,
heard?
those are the people that are following me and pressing charges against
That's
me.
it, Boatwright. That's what that's you.
Who's representing Mr. Boatwright?
I am.
Good morning, Ms. Holly. Is there an issue?
Mr. Boatwright, are you okay with doing this on video like we discussed?
Yes, please.
Okay.
Okay, thank you. Can you raise your right hand for me, Mr. Boatwright?
Mhm.
Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Well, they're jumping me, so I guess it's not gonna be easy.
Okay. Ms. Holly, I don't know if I'm going to be comfortable taking this plea if he's not able to answer a simple question as,
Would I be able to talk to him briefly? I spoke with him on Thursday. Could I be in a breakout room with him quickly or a phone call?
no, you're fine.
Now, Ms. Holly, you can call 404-612-2392. Get it over there for me.
404-612.
2392.
So stand back.
No, you're gonna go sit in this chair.
Okay, I'll call right now. Thank you.
Yes.
All right, thank you.
Your Honor, can we go to position number 23, Mr. Jackson, Robert Jackson, please?
Okay, thank you. And this is going to be an arraignment and a bond hearing, is that correct?
Just an arraignment, Your Honor.
Just an arraignment. Good morning, Mr. Jackson. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video? You're in mute courtroom too. Do you agree to have your case heard by video, sir?
Yes, sir.
Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
I do. Thank you, Mr. Jackson.
I apologize, Judge. Don't want to interrupt you. You were correct. It is a bond hearing and an arraignment.
Okay, thank you, Ms. Helen. Mr. Jackson, you have been charged in case 18 CR 008199Y with reckless driving, possession of an open alcohol container, driving under the influence of alcohol less safe. Each of these charges carries with it a maximum penalty of 12 months in jail and or $1,000 fine. Do you waive formal reading of the accusation, Ms. Helen?
I do, Judge.
How do you plead to these charges, Mr. Jackson? Guilty or not guilty?
I don't even know what that is.
We'll record your not guilty plea. Your case will be returned to the division judge and you'll get notification of your next hearing date. What is the current bond? Do we have that bond? Okay. Do we know the current bond, Ms. Helen?
No, Judge, I don't have that amount with me.
I was not able to find it either, Your Honor.
And that's why I wanted to see if a bond hearing is appropriate. I didn't see a bond with this charge. I wanted to see if the court or the state had that reflected anywhere.
Ms. Helen, why is he in? Did he get arrested on some other charge?
Correct, Judge. There is a felony charge.
Does that felony charge have a bond associated with it?
It does, Judge.
What is that bond?
Let me look that up. Give me 1 second, Your Honor.
And Ms. King, has your office, I don't have a bond for him. You all don't have a bond for him. Do I need to give him a bond, or I don't understand where we stand. Did he already have a bond at some point? Well, he must have had a bond at some point.
Judge, this was a bind over case and it was on Judge Edie's regular counter. This is the first time really appearing, so it was a bind over, and I guess they just added because he was incarcerated. So he has never been before Judge Edie for arraignment or anything at this point for this case.
Okay, do we know, was he arrested on a citation, or was he arrested?
Tickets, I'm trying to look it up right now.
And do we know what the felony charge that he got picked up on?
Yes, it was aggravated stalking and criminal trespass, 22 CP 211624. And from what I saw, it was no bond. I don't know if Attorney Helen was able to see something differently.
That is correct. He has no bond on the felony cases.
Correct, Judge.
Okay, so I'm just going to give him a bond on these charges. And there are going to be signature bonds through the jail for the reckless drive and $1,000 SOB through the jail for the possession of an open alcohol container, $500 SOB through the jail for the DUI, a $1,500 SOB through the jail. That makes it a total of a $3,000 SOB through the jail. No drugs, alcohol, weapons while out on bond. Did you
And
get
Judge,
that?
I'll get that bond modification order to Ms. Green.
Okay, thank you. Good luck to you, Mr. Jackson.
And Judge, he's not being held for these charges either.
Okay, thank you. Who do we have next?
We got position number 20, Mr. Johnny Holland.
It's going to be a non-negotiated plea.
Yes, Your Honor.
Good morning, Mr. Holland. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir. Good morning to you too.
Good morning, sir. Can you raise your right hand for me, please?
Yes, sir.
Do you swear from the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down, Mr. Holland. Is there a history, given that it's non-negotiated? Who do we have from pretrial this morning? Is anyone in for pretrial? Ms. Lewis, can you please call pretrial and let them know that we need someone this morning?
I thought somebody was just on the line for pretrial. I thought they logged in. I'll get them, Judge.
Okay, thank you. Good morning, Mr. Dudley. Is this your case?
Yes, Your Honor.
Okay. You can proceed.
This case took place on August 20th of 2022 at 3056 Steeplechase Drive. During the course of an argument with his fiance, the victim, Jasmine Marie Pittman, the defendant slapped her in the face, resulting in facial swelling of the nose and scratches to the upper part of her forehead on the left side of her temple area. And the defendant also hit the victim's vehicle driver's side mirror on her 2016 Mercedes CLS. As a result, he was charged with battery, family violence, and criminal trespass. The state recommended a offer for the battery, family violence of 12 months to serve, 50 days, credit for time served, 25 days, balance probated family violence intervention program, no further contact with the victim, Ms. Pittman, and to stay away from the incident location. As for the criminal trespass damage to property, 12 months to serve, 50 days, credit for time served, 25 days, balance probated to restitution for the damage done to her 2016 Mercedes CLS driver's side mirror to run concurrently with the first charge.
What's the amount of the restitution, Mr. Dudley?
The amount, we couldn't have the exact amount. I believe it was under $500.
Have you spoken with Ms. Pittman?
We have been unable to contact the victim.
Okay, I'm not going to order restitution if we don't have an exact amount of restitution. Anything further?
Nothing further from the state.
Ms. Helen, you have an issue with no further contact and the stay away?
I did reach out to Ms. Pittman yesterday. I do have contact information. From that, she wanted to have contact with Mr. Holland, and also he lives at that address with her, Judge. So I did give her the link for this morning's court appearance for her to appear. I'd like to give a call to see if Ms. Pittman is on the Zoom call.
What did Ms. Pittman tell you, Ms. Helen? Did you ask her the standard questions regarding contact?
I did, Judge. And she said she already spoken to the victim advocate and had given them the information that she wanted contact for it to be no violent contact and for him to return to that address, Judge.
What is their relationship?
Yes, Judge, they are currently in a relationship and they do share 5 girls from the ages of 10 years old to 1 year old.
Okay. Did you have any other issues, Ms. Helen?
No, Judge, you already handled the restitution. We didn't see a specific amount for it, but thank you, Judge.
All right. Anything further, Mr. Dudley?
Nothing further from the state.
All right. Mr. Holland, it's my understanding that in case 22 CR 005596J, you wish to plead guilty to battery, family violence, and criminal trespass. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol at the present time?
No, sir.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, sir.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept your plea, Mr. Holland. For the battery, it's going to be 12 months to serve, 50 days credit for time served, 25 days balance probated, family violence intervention program, no further violent contact with Ms. Pittman, and no drugs, alcohol, weapons while on probation. For the criminal trespass, 12 months to serve, 50 days credit for time served, 25 days balance suspended. I am going to waive the probation fees for you while you're on probation to help you get and stay on your feet, but you're going to have to be on probation for the entire 12 months. Okay, Mr. Holland?
Thank you. Thank you, Mr. Eric.
You're welcome, sir. Good luck to you.
Thank you, Judge.
Thank you. Your Honor, can we go back to position number 2, Mr. Boatwright?
Yes, Ms. Holland, we have an announcement for the court. Is he able to proceed?
Yes, Judge, I don't feel comfortable going forward with the plea today. He's having different memories of our conversation on Thursday. I would like to go forward with a motion for bond, and I'll submit a competency mental health order as well.
Okay, what is his current bond?
He currently has a cash bond of, I believe, $2,000. He was picked up on an FTA. He does live at a mental health assistance facility. He has a social worker there. I've spoken with her. I believe the only reason he failed to appear in court is because he did not know to inform the court of his new housing. But he does have a social worker and a support system there. It's a housing project called Welcome House, specifically for people with mental health issues. So I would ask that you just set a signature bond and he be released so that he can return to court and we can handle this mental health competency order from out of custody. He's already been in for 55 days on this charge.
Do we have his bond? Thank you. And Ms. Holly, you tell me that he has that he is in a mental health facility.
It's a mental health housing development. So it's a supportive housing for those with behavioral health needs. They're each assigned a caseworker. He does live independently, but they help him with medication, seeing a doctor, jobs, things like that.
Okay, Mr. Dudley.
Yes, Your Honor. We're unaware that he was in a mental or had this mental issue. I believe he was given that surety bond based on the fact that he does have that FTA. I'll defer to the court's judgment on this bond hearing.
Okay. Ms. Holly, I think this is the first time that you've been in court with me.
It is.
You are welcome. What I normally do is if I modify a bond, the attorney that's requesting it completes that bond for me. So if you will do that today, it looks like he did have $1,000 I can't tell if it was a
Surety bond, Your Honor.
Well, he initially did, but Judge Edie specifically put on his record that it's to be a cash bond only.
Judge Edie has been doing cash bonds for anyone who's picked up on an FTA.
Right, and what I normally do is I normally send it back to the division judge that ordered the cash bond for them to determine whether or not they want to modify that bond. And I think that I'll stick with my practice. I understand that he's been in and that he may have some mental health issues, but I'm going to return this to Judge Edie to let him decide whether or not or how he wants to deal with the modification of that bond. Okay.
Understood. Okay, I'll reach out to him and to the prosecutor in our courtroom. Thank you.
Thank you. Good luck to you, Mr. Boatwright. Thank you. All right, who do we have next?
Position 34, 4 South.
And so 4 South, this is Mr. Sylvie. Is that right?
Yes, sir.
Okay, good morning, sir. This is going to be a negotiated plea.
Yes, Your Honor.
Good morning again, Mr. Sylvie. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Thank you. Ms. King.
Good morning, Your Honor.
Good
The
morning.
offer is time served 15 days.
Okay.
Yes, Your Honor. That is our understanding of the plea. It's a time served, balance suspended. We do accept that plea. We do stipulate to the factual basis, venue, and ID.
Mr. Sylvie, it's my understanding that you wish to plead guilty to expired or no license and giving false information to law enforcement. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, sir.
You understand that you have a right to a trial by jury on these charges and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No. No, sir.
I'll accept your negotiated plea, Mr. Sylvie. Good luck to you, sir. Who do we have next?
Your Honor, we have position number 31, Mr. Timothy Rutledge, in courtroom 2.
Good morning, Mr. Rutledge. I'm Judge Eric Morrow. This is a state all-purpose calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down, Mr. Rutledge. Ms. King?
Yes, Your Honor. The offer is 12 months to serve 46 days, credit for time served 23 days with the balance probated, 40 hours of community service, and to stay away from all MARTA.
Yes, Your Honor. That is our understanding of this time served plea. Mr. Rutledge accepts it. this plea, we do stipulate to the factual basis, venue, and ID. It is a probated sentence, so Judge, can we have those probation fees to be waived? And if the state is amenable, can it be non-reporting once he completes the 40 hours of community service?
No objection to non-reporting.
Okay. Mr. Rutledge, is my understanding that you wish to plead guilty to 2 counts of criminal trespass. Is that correct?
Sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, sir.
You understand that you have a right to a trial by jury on these charges and that by pleading guilty to them, you've given up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
Okay, I'll accept the plea as negotiated, Mr. Rutledge. I'm going to waive your probation fees while you're on probation to help you get and stay on your feet. And when you complete the terms, it'll go to a non-reporting status. So the quicker you get that 40 hours of community service done, the quicker you don't have to report to probation, okay?
Okay, can I ask a question?
Mr. Rutledge, if it's about the conditions, I can give you a call and give you more explanation.
You know, is there any detainers I have?
Judge, he wants to see if he has any holds. I didn't see any holds on Odyssey.
Okay. I wouldn't know if he has a hold or not, Miss Helen, but if you say that he doesn't, then I presume that he doesn't.
Mr. Rutledge, I didn't see any holds when I last saw you, okay?
Okay, thank you.
Thank you.
Who do we have next?
Next, we have position number 12, Mr. Crawford.
Officer, I want to get to
Well, I'll get some water.
Good morning, Mr. Crawford. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir. Good morning.
Good morning. Can you raise your right hand for me, sir? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, thank you. Mr. Dudley.
Yes, Your Honor, the state's recommendation is going to be time served and a stay away from 485 Lindbergh Place, Northeast.
Good morning, Mr. Ford.
How you doing, Your Honor?
Doing
We do concur with the recommendation of the state. I've spoken with Mr. Crawford and he will be accepting this plea. He will be doing a guilty plea at this time.
All right, Mr. Crawford, it's my understanding that in case 22 CR 005868E, you wish to plead guilty to loitering and prowling and willful obstruction of a law enforcement officer. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, sir.
You understand that you have a right to a trial by jury on these charges and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, sir.
Is anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated. Good luck, Mr. Crawford. Okay, given that there's a stay away, Mr. Dudley, can you tell me, is it 485 Lindbergh Place?
That was, one second, let me pull that back up, Your Honor.
I think it's the Ashton apartment complex, Your Honor.
Okay, and are those at 485 Lindbergh Place?
485 Lindbergh Place.
Yeah.
Northeast, yes.
For the entirety. Okay. Oh, I'm sorry. And how many days has Mr. Crawford been in custody?
15 days, Your Honor.
So 15 days credit for time served, 15 days.
That's correct, Your Honor.
Okay. Thank you. Good luck to you, Mr. Crawford. Who do we have next?
position 27 on 4 South.
And this is Mr. Marvel.
Yes, sir.
This is going to be an arraignment and a bond hearing.
Just an arraignment, Your Honor.
It's an arraignment, all right. Good morning, Mr. Marble. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Thank you. You can put your hand down. Mr. Marble, you've been charged in case 21 CR 001611J with operating a bicycle on a sidewalk, wrong way on a one-way street, obstruction of a law enforcement officer, possession of marijuana less than an ounce, and carrying a weapon without a valid license. Each of these charges carries with it a maximum penalty of 12 months in jail and/or $1,000 fine. Do you waive formal reading of the accusation? Ms.
I
Hack?
do, Your Honor.
How do you plead to these charges, Mr. Marble? Guilty or not guilty?
Not guilty.
We'll record your not guilty plea. Your case will be returned to the division judge, and you'll get notification of your next hearing date. Good luck to you, sir.
All right.
Thank you, Judge.
Who do we have next?
Position number 8, Mr. Nicholas Chesson.
This is not negotiated.
That's correct, Your Honor.
Good morning, Mr. Chastity. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Thank you. You can put your hand down. May I get his history, please? We still have someone on for pretrial?
Yes, Your Honor. Give me 1 second.
Okay.
I'm
good.
doing this. I'm a little behind. I'm sorry.
Okay, you're fine.
It's position 8.
Yes, it is.
Your Honor, the only issue is the NOLO and a one-time to get his things.
I need to know whether or not he has any violence in his past. So I can.
That's fine, Your Honor. I just wanted to give you a precursor to that.
Okay.
As pretrial is looking it up from what the state has found, he has 1 arrest in Florida, 2 arrests in California, 2 arrests in Nevada, and a total of 4 Cyclopedia, Georgia. He's been convicted of burglary first degree in California in 2013 and theft in Nevada 2015 and 2017.
All right. Given that, Mr. Ford, I'm not going to allow him to use a NOLO. And I don't think a first offender would be appropriate. So it'll be a guilty plea, a straight guilty plea if he wants to plead to the battery family violence.
Did you hear that, Mr. Chesson? That you would have to plead guilty. The judge is not going to accept the NOLO or first time. I apologize, Your Honor. I didn't have the other state information.
That's fine.
Did you hear that, Mr. Chesson?
Yes, sir.
Are you willing to plead guilty to the charges against you today?
Yes.
We can proceed, Your Honor.
Okay, Mr. Dudley.
The state's recommendation is going to be 12 months to serve, 34 days, credit for time served, 17 days, balance probated, no further contact with the victim, Catherine Laval, and stay away from the incident location, 1197 Virginia Ave Northeast, and a family violence intervention program. Nothing further from the state.
Mr. Ford.
Yeah, thank you, Your Honor. My client will accept that. We'd ask for a one-time police escort to retrieve his personal items at this time.
Okay.
Oh, Your Honor, and also we'd ask that his probation fees be waived, and once he's completed his conditions, that his probation be terminated.
Given the nature of the charge, I'm not going to allow it to be terminated. If agreeable with the state, I'll allow it to go non-reporting when he completes the the terms of the probation. Is that fine with you, Mr. Dudley?
Yes, that's fine with the state, Your Honor.
Okay. Mr. Chastain, it's my understanding that in case 22 CR 005859D, you wish to plead guilty to battery family violence. Is that correct?
Yes, Your Honor.
Were you under the influence of any drugs or alcohol this morning?
No.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, sir. Absolutely.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, Your Honor.
Has anyone forced or coerced you to plead guilty?
No.
I'll accept the plea, Mr. Chastain. It's going to be 12 months to serve, 34 days, credit for time served, 17 days, balance probated. No further contact with Ms. Laveau. Stay away from the 1197 Virginia Avenue address. You can go back to that address on one occasion with law enforcement to retrieve any belongings that you might have there. I'm going to waive the probation fees for you while you're on probation to help you get and stay on your feet. And when you complete the terms, it'll go to a non-reporting status, okay?
Yes, sir.
All right, good luck to you, sir.
Thank you.
Who do we have next?
Position 4, 4 South.
Just an arraignment.
Yes, Your Honor.
And is it Broaders?
Yes, it's Broaders, Your Honor. Yes.
Okay, good morning, Mr. Broaders. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes.
Can you raise your right hand for me, sir? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
I do.
Okay, you can put your hand down. Mr. Broaders, you've been charged in case 18 CR 010895Y with discharge of a firearm near a public highway or street, battery family violence, battery against a female who is pregnant. Each of these charges carries with it a maximum penalty of 12 months in jail and or $1,000 fine. Do you waive formal reading of the accusation, Mr. Ford?
Yes, we do, Your Honor.
How do you plead to these charges, Mr. Broaders? Guilty or not guilty?
Guilty.
Well, Mr. Broaders, we talked about it. You said you're going to plead not guilty today.
I thought about it further, and there's no need to hold the court.
I will have to speak with you maybe in a breakout session or by phone, Your Honor, because he was very adamant about pleading not guilty yesterday.
Okay, and it's my understanding that the state is asking for 24 months to serve. Is that right?
That's correct, Your Honor. We're not going to have Mr. Broaders plead to 24 months to serve, Your Honor. At this time, Mr. Broaders, I'm going to enter a not guilty plea for you. You understand? Mr. Broaders?
I'm not understanding because I'm in perfectly sound mind, and I want to plead.
We'll speak about it because there's other charges that are holding Mr. Broaders in, Your Honor, and
you want to put this on next week's calendar, Mr. Ford?
Yes, that would be good, Your Honor.
Okay.
We need to talk with Mr. Broaders again because we're going to have him plead 24 months.
All right.
Time.
Ms. Lewis, has the calendar already gone out for next week?
For the 20th, it will be processed this week. So you still have time to put it on for the 20th.
Okay. Well, I'm not going to be on the SAP calendar next Tuesday, Mr. Ford. If you want me, that'll be 2 weeks from today. If you don't care who the judge is, we can put it on for next week.
Yeah, Your Honor, we can put it on for next week because we'll have an opportunity to speak with Mr. Broaders.
Okay, so we'll put it on for next Tuesday. All right, we'll see you back then, Mr. Broaders. Good luck to you, sir. Who do we have next?
Your Honor, we have position number 39, Mr. Marcus Williams.
And that's a private attorney, Your Honor?
Yes, Your Honor. I've been speaking with the attorney on this case. If we may come back to it, we're still negotiating.
Hi, excuse me.
Okay, you're still negotiating over a time served plea?
Hi, I'm Overton Theory.
Yes, Your Honor.
Your Honor. Hello?
I'm speaking with Attorney Partridge now.
That's Overton Theory is the attorney for this matter.
Yes.
Oh, my apologies.
Mr. Thierry, good
Hello,
morning.
Your Honor. Good morning, Your Honor. My client would like to go forward with a plea.
Okay, and it's my understanding that it's gonna be time served 9 days, is that right?
Yes, Your Honor.
Yes, that is correct.
Okay, this is position 39.
That's
What's the-
Marcus Dwayne Williams.
Okay, and what's the chart, what are the charges, Ms. King?
It is battery and simple battery, Your Honor.
From my understanding, we're going forward with simple battery.
Is that right, Ms. King?
That was not my understanding. One moment, Your Honor.
I spoke with Mr. Theory yesterday, and that was not the conversation, but due to the age of the case, I will oblige, Your Honor.
Okay, I'll send an all cross right over, Your Honor.
Okay, so you're now processing the battery and he's pleading to a simple battery that occurred back in 2003.
That's correct.
And the terms of it will be 12 months to serve 9 days, credit for time served 9 days.
That's
Is that right?
yes, Your Honor.
Yes, Your Honor.
Okay, are we all in agreement with that?
The defense is, Your Honor.
Yes, Your Honor.
Okay. Do I need to hear anything further on this before I take the plea?
Nothing from the state.
Nothing from the defense, Your Honor.
Okay,
We want
thank
to
you.
stipulate to the facts, factual basis.
All right, Mr. Williams, good morning. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Good morning, Your Honor. Yes,
Good morning. Can you raise your right hand for me, sir?
yes, sir.
Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down, Mr. Williams. It's my understanding that in case 05CR300397, you wish to plead guilty to simple battery. Is that correct?
Yes, Your Honor.
Are you under the influence of any drugs or alcohol this morning?
No, Your Honor.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, Your Honor.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, Your Honor.
Is anyone forced or coerced you to plead guilty?
No, Your Honor.
I'll accept the plea as negotiated. Good luck to you, Mr. Williams.
Thank you, Your Honor.
All right. Do you have any further business before the court, Mr. Theory?
No, Your Honor, I would like to come down to the court to get the plea paperwork and sign the plea paperwork.
Mr. Thury, do you have an email? I can email it to you, but if you want to come down to the court, you're more than welcome.
I'm in the courthouse. Yes, I would like to. Which courtroom would it be?
G33.
All right, I'll be there shortly. Thank you.
Okay.
Thank you, Your Honor.
You're welcome. Who do we have next?
Good morning, Your Honor. This is the South Annex. We will go right after for South with position. Thank you. Sorry about that, Your Honor. With
That's
position
fine.
38 after 4 South, and if it's possible, after 4 South, may I please do position 5 and 11?
All right. Good morning, Officer Nelson. So we'll go to 4 South and we'll come back to the South Annex and do 5
Thank
and
you.
11. Who do we have at 4 South?
Position 33.
And this is going to be a negotiated plea.
Yes, Your Honor.
Good morning, Mr. Smith. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
You put your hand down. Ms. King.
Yes, Your Honor. The offer is 12 months to serve 82 days, credit for time served 41 days with the balance probated, an MHET, a stay away and no further contact. The stay away address is 258 Siple Terrace, SCIPLE. And the no further contact is with Shundra Smith, SHUNDRA, last name traditional spelling.
Yes, Your Honor, that is our understanding of the plea. We do accept that plea. We do stipulate to the factual basis, genuine ID.
Is there any need for him to be on probation after he receives the MHET?
Let me look. No, well, he has an open felony case. So at this time, the state will be requesting that it non-reporting at the very least, Your Honor.
Any objection to non-reporting, Ms. Helen?
No, Judge.
Okay. Mr. Smith, it's my understanding that in case 22 CR 0000030F, you wish to plead guilty to terroristic threats. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, sir.
Has anybody forced or coerced you to plead guilty? Nobody's making you plead guilty, are they, Mr. Smith?
No, sir.
I will accept the plea as negotiated. Mr. Smith, I'm going to waive the probation fees for you while you're on probation. And when you complete the terms, it'll go to a non-reporting status, okay?
Yes, sir. Thank you, Mr. Air.
You're welcome, Mr. Smith. You have a good day, sir.
All right.
Thank you, Judge.
All right, so I think we're going to go to position 5 now at the South Annex. Is that right?
I believe that's my position.
Position 38. Gabrielle Williams is sitting in front of you, sir.
Okay. 38 is a negotiated plea.
Yes, Your Honor.
Good morning, Ms. Williams. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
He's asking a question.
Yes.
Okay. Can you raise your right hand for me, Ms. Williams? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can put your hand down. Thank you, ma'am. Who's presenting for the state?
This is position 5, Your Honor.
This is position 38, Ms. Williams.
That will be me, Your Honor.
Okay, whenever you're ready, Ms. King.
The offer is it is time served 3 days with a stay away from 80 Anderson Avenue, which is a MARTA station.
Okay. Ms. Helen?
Yes, Judge, that's our understanding of the plea. We do stipulate to the factual basis, venue, and ID.
Ms. Williams, it's my understanding that in case 22 CR 001419G, you wish to plead guilty to criminal trespass. Is that correct? Can you hear me, Ms. Williams?
Mr. Williams, he's asking you a question. Answer him.
Hey, Miss Williams, the judge is talking to you, okay? So listen to his questions and just answer yes or no, okay, as you understand the question.
Okay. Ms. Williams, first, can you hear me okay, Ms. Williams?
Yes.
Okay, so I asked you if you want to plead guilty to this criminal trespass charge. That would be a yes or no. What's the problem, Ms. Williams?
Hey, Judge, can we reset this to next week? I'm gonna get a social worker out there, okay? Talk to Miss Williams.
Okay. Do you want to reset it till next week? I mean, she
does have another case holding her.
Oh, she does? Okay.
Yes, Your Honor, she does.
Okay, all right. So we'll reset it until next Tuesday.
Understood, Judge.
Okay, South Annex, are we going to position 5 now?
Yes, you're Miss Brooks. Come on, switch. Have a seat over there.
All right, so what's the issue with Miss Brooks?
You did not tell us. Thank you.
Your Honor, as I was interviewing Ms. Brooks, she did break off the interview. I did not get any information. Based on what listening to her, she may want to go pro se, Your Honor, because she does have a time served situation. And at this point, I did not want her not to come today. to see if she wanted to represent herself. Your Honor.
Good morning, Ms. Brooks. Can you hear me okay? You're gonna have to answer verbally for me, ma'am. Can you hear me?
So yes or no? He asked you a question. Can you hear him? Speak yes or no.
Oh, yeah, yes, no.
Okay. Good morning, Ms. Brooks. Let me just first tell you, you have a right to remain silent. Anything you say can and will be used against you. You also have a right to have an attorney present at these proceedings. It's my understanding that Mr. Ford was willing to represent you from the Public Defender's Office. Do you want him to represent you, ma'am?
Yes or no? Oh, yeah.
Okay, so would you like to talk to Mr. Ford about this? The state is offering a time served plea on this matter. Would you like to speak with Mr. Ford regarding that?
No.
Okay. All right, so what would you like to do, Ms. Brooks?
Okay.
Okay, I think that we need a mental health evaluation, Mr. Ford. So what is the current bond on this matter?
Your Honor, she received a signature bond on this particular criminal trespass, but she does have 2 other cases that have significant bonds on them.
Okay, so before we move forward with this case, I'm going to add a mental health evaluation to whatever current bond that she has. So do we have her bond?
I believe that is, she has a $20,000 bond, surety bond on aggravated assault felony, and a $5,000 surety bond for possession of firearm or knife during commission of certain felonies.
She's not in jail for this charge, Judge.
I understand that, but I'm going to modify the bond that she is in jail for, this criminal trespass bond. It's going to be a $500. And if you could take this down for me, Mr. Ford, I'd appreciate it. It's going to be a $500 good bond, a mental health evaluation, stay away from 14 Hilliard Street, and no drugs, alcohol, or weapons while out on bond. I believe that Ms. Brooks needs a mental health evaluation before we can move forward with any of her cases. All right, thank you, Mr. Ford.
Thank you, Your Honor.
Okay, have a seat back over there. Next, we have position 11, Ms. Craig. Have a seat there, please.
I'm going to have to the company's calendar. All right, and this is Ms. Craig, is that right? Yes. Good morning, Ms. Craig. Is Ms. McLeod on?
Oh, can you?
Oh, no, I'm sorry. This is
I am on, Your Honor, but this is not my case.
Oh, okay, good morning, Ms. McLeod. I'm sorry.
Good morning, Your Honor.
So this is going to be an arraignment and a bond hearing, is that right?
That's correct, Your Honor.
All right, good morning, Ms. Craig. I'm Judge Eric Morrow. This is the state all-purpose calendar. Yeah, good morning. We're conducting this calendar by video. Do you agree to have your case heard by video?
I'm not sure who's all listening. Like, I see what I'm seeing on this side is kind of confusing because I mean, I want to be in person, but I would prefer if I was in person, but at the same time, I don't want to be in here longer, and then I don't want to make a decision because I'm frustrated.
Okay, and I don't want you to make a decision because you're frustrated either, Ms. Craig.
I took drugs before I did it.
So this morning, you're going to have an arraignment on these charges, and it's my understanding that you plan on pleading not guilty to them. Is that right?
Yes. Well.
So my question to you is, can we do that over video?
I know, it's every time for that.
Are these people that I'm?
She already has,
Oh, okay, I see. Okay, I see.
Okay, but I'm saying that.
may I see your bond, please?
Yes, we can. I am just, I actually kind of wanted to plead, self-defense and.
Okay, so you're pleading not guilty, is my understanding.
Yes.
Ms. Craig.
Yes.
Okay, so can we go forward with you doing that over video? Is that all right with you?
Yes, do I get is it a record of this that we're doing on video?
Yes, ma'am, there's a record.
Okay.
Okay?
Okay.
All right, so can you raise your right hand for me?
Yeah.
Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can put your hand down. Thank you, Ms. Craig. You have been charged in case 19 CR 0088881Y with battery, family violence, and battery against a female who is pregnant. Each of these charges carries with it a maximum penalty of 12 months in jail and/or $1,000 fine. Mr. Ford, do you waive formal reading of the accusation?
Yes, we do, Your Honor.
How do you plead to these charges, Ms. Craig? Guilty or not guilty?
These charges were transferred to a different state and they were already resolved.
Okay, so they've not been resolved at this point. So it's my understanding that you were going to plead not guilty to them. Is that right, Ms. Craig?
Yes, but I'm confused on how are they not resolved? That I've never been to jail before, but when I went to Michigan, the case manager transferred them and they put me in a psych ward multiple times. And I also did jail time for that.
Okay, so I'm going to let you speak with Mr. Ford later in regards to all that, Ms. Craig. But for today's purposes, it's my understanding that you're pleading not guilty. Is that right?
Yes. Okay. Yes.
All right, very good. So we'll record your not guilty plea. In your case, it's going to be returned to the division judge, and you'll get notification of your next hearing date. Do we have the bond?
Yes, Your Honor. She has $3,500 on both charges, and we're asking for those to be signature bonds due to the fact that the state has offered her time served. She's been in jail, incarcerated for 212 days. And she does have a couple other cases that are holding her in. But once these charges are signature bonds, Your Honor, she may be having an opportunity to bond out.
And what is she being held in that's on, Mr. Ford?
Let's see here. She's held on battery, third or subsequent offense. That's the major felony that she's held.
Okay, so I'm going to let her deal with those felony charges, and if she makes bond or gets reduction in bond on those charges, then of course you can bring it back, and I'll consider modification. Okay.
Well, Your Honor, due to the fact that the state is offering time served, I would ask that we do a signature bond on these two cases so that she can deal with the two felony cases and possibly make bond, because one is $4,500, the other is only $500, so she has a total of $5,000 of bond. If these two cases are dealt with today, there is a possibility that Ms. Craig will be able to bond out.
Okay, well, I'm not comfortable doing that, Mr. Ford, simply because I also think that there's an issue with mental health in this matter. So given that, my decision is going to stand. If she makes bond on those other matters, then you can come back and reconsider this. Good luck to you, Ms. Craig. Who do we have next?
Can we be excused, Your Honor?
Yes. Am I going to see you this afternoon, Officer Milton?
No, sir, but I'll log in just to say hello.
All right, you have a good afternoon.
You too. Bye.
All right.
We have position number 36 in courtroom 2.
Okay. What are we doing with Mr. Trammell?
Good morning, Your Honor. Bronte Partridge on behalf of Mr. Trammell. Judge, it's my understanding my client, this case is pretty old. My client has done time in prison and had no clue about this case. He was in a car accident last week and was picked up on an FTA for this case and a 2004 case. The 2004 case has since been dismissed as of Friday. So we're, I guess, if the state is not willing to dismiss this one as well, we're asking the court to consider a signature bond for the two charges, the stop sign and the marijuana.
Mr. Partridge, I hate to cut you off, but it's my understanding that the state has already null pros these. Is that right, Ms. King?
We have null pros position 36, but not 37, Your Honor, due to the fact that there was a victim in position 37.
Okay, the running of stop sign?
Right.
Yes, position 36, we did no pros. I've already submitted that to Miss Grace. The position 37 involved.
What do you want him to do on a 2001 running of a stop sign?
We
It's
can
no
dismiss
pros.
the position 37. I was just looking into the defendant's history, and he did 5 years in prison afterwards. So I mean, if we didn't handle the case by then, it's fine.
I'm sorry, but on the screen, you submitted position 37 as a null pros. That's what's recorded, and that's what you wrote on the null pros.
Right. Yeah, I'm sorry, Ms. King. I do have that you have a null pros with position 36, those charges. So what are you going to do with position 37? Are you going to null pros that also?
We're going to null pros both of them, Your Honor.
Okay. All right. So I'll sign those null pros. Anything further, Mr. Partridge?
That's all for me, Judge. May I be excused at this time?
Yes. Have a good day.
Judge,
You also have a
Can
great
I
one.
just
Mr. Trammell, your cases are dismissed.
Thank you, Your Honor.
Okay.
Can I just make it clear? We just need a null pros for position number 36. You already submitted one on 37 on September the 9th.
Good. I will send it right now. Thank you.
Okay. Thank you.
Thank you all.
All right.
Next, we have position number 24, Mr. Earl Jones.
And this is going to be an arraignment and a bond hearing.
That's correct, Judge.
This is position 24. Good morning, Mr. Jones. I'm Judge Eric Moore. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes.
Thank you. Can you raise your right hand for me?
Before we need to tell him now.
Oh, yes. Your Honor, I have something to say. I want to speak to my attorney. I have some new information on the case.
I'll call
Okay.
courtroom
All
too.
right. So we're going to give you that opportunity, Mr. Jones, but this morning, it's my understanding that we're going to start off with an arraignment, okay, that you're going to plead not guilty to. Is that is my understanding correct?
Yes, that's correct.
Okay, so why don't we do that first, sir? So can you raise your right hand for me?
Yes.
Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can put your hand down, Mr. Jones. You've been charged in case 22 CR 005862Y with one misdemeanor offense. This charge carries with it a maximum penalty of 12 months in jail and/or $1,000 fine. Do you waive formal reading of the accusation, Ms. Helen?
I do, Your Honor.
How do you plead, Mr. Jones? Guilty or not guilty?
Not guilty, Your Honor.
Okay, we'll record your not guilty plea. Your case will be returned to the division judge and you'll get notification of your next hearing date. I set this bond for Mr. Jones back on August 30th. This was a $3,000 good bond with a stay away from Ms. Collins and from Marta. Ms. Helen, has anything changed since I set the bond?
Well, Judge, when I spoke to Mr. Jones, yes, he is requesting a jury trial for this, but he's got some more information that he wants to give me. I think that may be the change, but specifically, Judge, the change from the original date is that when I spoke to Mr. Jones, he advised me that there is definitely an identification issue here. Again, that's why we're going to the jury trial, Judge. But we are still asking for that bond modification because he's not been able to make that $3,000 surety since it's been set. And so, Judge, yeah, we were looking for a bond modification of $3,000 signature for Mr. Jones. And if not a signature bond, Judge, a bond reduction to $1,500.
Good morning, Ms. Harrison. Is there, what's the history for Mr. Jones?
Good morning, Judge. I have 9 cycles with arrests in Georgia and South Carolina. No disposition listed on his GCIC, Judge.
And are those the only,
He had, his last arrest was December of 2021 for failure to appear. Underlying charge is simple battery under case 15 CR 013120B like boy.
is that an open case?
It's a
It's
conviction.
not chosen.
It's a conviction, Your Honor.
Okay, a 2021 conviction for simple battery, is that right?
2014. I have a 2014 conviction.
Yeah.
2014, okay. And nothing since 2014, Ms. Harrison?
No, Judge. His arrest of South Carolina was early 2000, like 2001 through 2004, I believe.
Okay.
2003. His last conviction was in South Carolina, 2003, arson first degree.
Okay, thank you, Ms. Harrison. Ms. King?
Yes, Your Honor. We've been in close contact with the victim in this case. She stated that she does not know him and had not seen him prior to that incident. She says she's severely traumatized from this incident and she has been afraid to ride the bus since it's happened. She's been having to spend extra money on Ubers due to being in fear of running into the defendant again. She says she's especially afraid to ride MARTA at night, which is tough for her with her employment. And she is adamant on making sure this defendant does not do it to someone else. She's a cooperative victim and due to the trauma that's been sustained to her and the state is concerned that he is a danger to citizens of Fulton County at large. We're asking that the bond remain as set, the 3,000 surety you set, Your Honor.
Ms. Helen, you say that he can make a $1,500 good bond?
Can I get an opportunity just to speak to Mr. Jones?
Of course. Are you gonna call?
I can call.
All right. Courtroom 2, can we go? Well, we have someone in medical. Can we go to whoever's in medical?
Yes, this is position number 19, Mr. Howard.
And who's representing position 19? Ms. McLeod?
I'm representing him.
And what are we doing with him this morning?
Your Honor, there is a plea offer. I had spoken to him briefly a couple of days ago, but I didn't want to just make sure that he is amenable to the offer today. His mom is actually on the Zoom as well.
Okay, so do you need to go into a breakout room with him, or how do you need to do that?
Yes, or speak to him on the telephone, Your Honor.
Okay, medical.
There's no phone, so you have to do a breakout.
Okay.
Okay, so if we can put medical and Ms. McLeod into a breakout room, please.
All right, Judge, can we do position 14, Douglas?
Yes, who's representing position 14? Because we have 2 attorneys in breakout, so.
I think I am, Your Honor. Hold on, let me. Yes, I have Mr. Douglas.
All right, this is just going to be an arraignment?
Yes, Your Honor.
Okay. Good morning, Mr. Douglas. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video? Can you hear me, Mr. Douglas?
Yes, sir. Yes, sir.
Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down, sir. Mr. Douglas, you have been charged in case 19 CR 002092Y with driving while your license was suspended or revoked and simple assault family violence. Each of these charges carries with it a maximum penalty of 12 months in jail and/or $1,000 fine. Do you waive formal reading of the accusation, Mr. Ford?
Yes, we do, Your Honor.
How do you plead to these charges, Mr. Douglas, guilty or not guilty?
Not guilty.
We will record the not guilty plea. Your case will be returned to the division judge and you'll get notification of your next hearing date. Good luck to you, sir. Who do we have next?
We got position number 30, Mr. Carl Roberts in courtroom 2.
Is this one of Ms. Helen's cases?
I believe it is, Your Honor.
It's Ms. Helen? Okay.
All right.
Can we
It's
go
in the low numbers, Your Honor.
Can we go to position number 3, Mr. Jesse Bray?
Ms. McLeod is also in a breakout room.
Okay. I think Ms. Helen is back. Ms. Helen is back.
Yeah, we're on for 24. We're ready for 24, position 24.
Come on. No, you should do. Roberts, you sit there. Jones, you sit in the green chair. Let's get it together.
Okay,
Position 24, Your Honor.
all right, so Ms. Helen?
Yes, Judge, I spoke with Mr. Jones. He is not able to afford that $1,500 bond because he's spoken to a bond person who's not able to bond him out, Judge. So, Judge, we are asking for that signature bond specifically because of his history. We don't have repeating violent sexual crimes at all. This is not a history lifetime offender. He has been at Gateway for the last 2 years. He would like, upon his release, to go back to Gateway. And in fact, Judge, he has a housing voucher from Gateway that he just received. Judge, if he is to remain incarcerated, he will lose that voucher. He will no longer be able to participate in Gateway. And Judge, he also wanted me to let you know he is a proud father of 3 children who he is in contact with, and he's a lifetime Fulton County resident. So yes, Judge, we are asking for a signature bond for Mr. Jones in the amount of $3,000. And Judge, he's not able to make any other bond since it's been set at the $3,000 surety. So yes, we are asking for that bond modification to a signature bond.
Okay, I've heard your argument, Ms. King. Do you have anything further?
The victim is pretty strong in her feelings in this case, and I ask Your Honor to take that into strong consideration.
Okay. I set this bond. I'm going to modify the bond. It's going to be a $5,000 signature bond through the jail. No further contact with Ms. Collins. Stay away from MARTA. So he cannot go back to MARTA, Ms. Helen. So he's going to have to find himself some other mode of transportation.
You hear that, Mr. Jones?
Yes, I hear that. Yes.
That's all MARTA. That is all MARTA, okay?
And he is to have housing at Gateway. Which is where I'm told that he has a voucher for. So I'm giving you the opportunity to sign yourself out, Mr. Jones. But if you go back to MARTA and you're picked up anywhere on MARTA property, then this bond's going to be revoked. Do you understand what I'm saying?
Yes, sir. Yes, sir.
All right. Good luck to you, Mr. Jones.
Thank you, Judge.
All right, position 26.
And I see you back, Ms. McLeod. What are we going to do with?
Your Honor, my client wishes to take a plea. There is just one condition of the plea which we wanted to discuss with the court, and because part of it requires no contact with his mom. His mom does want contact, Your Honor, but otherwise we are okay with the terms.
Tell me what position this is again, please.
It is a position. Just a moment.
Number 19.
19. It's position 19.
Okay, and is this his mom? Is this Shelley Hauser that's on, Ms. Hauser?
That is correct, Your Honor. That's mom.
Okay.
And Your Honor, if his mother wants contact, the state is fine with that. We just ask for no violent contact. That would not be an issue at all.
Okay, so do you want, and this is, I'm sorry, Ms. Hauser, this is your son?
Yes.
Michael?
Yes,
All right,
sir.
and you do want contact with him?
Yes, Your Honor.
Okay. Does he live with you, Ms. Hauser?
Always.
Okay, all right. Okay, thank you, ma'am. I appreciate it. Let's see. Who's presenting for the state?
I am, Your Honor.
Okay, go ahead, Mr. Dudley.
The recommendation is going to be 12 months to serve, 38 days, credit for time served, 19 days, balance probated, stay away from the incident location, or we're going to do away with that. And we're going to have no further violent contact with Shelley Hauser and MHET. Nothing further from the state.
Okay. Anything further, Ms. McLeod?
We just want to make sure that he does get the MHET, Your Honor. That is important to her.
Okay, so once he receives it, I'm going to waive the fees for him while he's on probation to help him get and stay on his feet. And when he completes the MHET, I'm going to have it go to a non-reporting status. Anybody object to that?
No objection.
No, Your Honor.
Okay. Anything further before I take the plea?
No,
Okay.
Your Honor.
Good morning again, Mr. Hauser. We're conducting this by video this morning. Do you agree to have your case heard by video?
Yes, sir.
Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can put your hand down, Mr. Hauser. You've been charged in case 22 CR 005759G with criminal trespass. It's my understanding you wish to plead guilty to that charge. Is that right?
Yes, Your Honor.
Yes.
Are you under the influence of any drugs or alcohol this morning?
No.
You've been represented by counsel. Are you satisfied with her representation?
Yeah.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes. I did have a question.
Hold on, Mr. Hauser. Just, you have a right to remain silent, and anything you say can be used against you. If you have a question, I'm happy to let you speak with Ms. McLeod about that.
Oh, that's fine. That's fine.
Okay? I just don't want you to say something that can get you into more trouble, okay?
That's fine. I won't have to say.
Has anybody forced you to plead guilty?
No.
Okay. I'm going to accept the plea as negotiated, Mr. Hauser. And I'm going to waive the fees for you while you're on probation to help you get and stay on your feet. And when you complete the terms, it'll go to a non-reporting status, okay?
Okay, thank you.
All right. Good luck to you, sir.
Thank you, Your Honor.
Thank you. Good luck to you also, Ms. Hauser.
Thank you so much.
You're welcome. All right. I'm sorry. Courtroom 2, who do we have next? Or are we going to courtroom 2 or we're going to go to 5 South?
26.
26. And this is Mr. Lancaster that we're going to have an arraignment and a bond hearing for. Is that right?
That's correct, Judge.
Good morning, Mr. Lancaster. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, Your Honor.
Can you raise your right hand for me? Do you swear from the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
You can put your hand down. Thank you, Mr. Lancaster. You have been charged in case 22 CR 005849C with simple battery family violence. This charge carries with it a maximum penalty of 12 months in jail and/or $1,000 fine. Do you waive formal reading of the accusation, Ms. Helen?
I do, Your Honor.
How do you plead to this charge, Mr. Lancaster? Guilty or not guilty?
Not guilty, Your Honor.
Okay, I'll record your not guilty plea. Your case will be returned to the division judge, and you will get notification of your next hearing date. In regards to bond, I set this bond back on August 30th. It's a $7,500 good bond with a stay away and a no further contact. Has anything changed since I set this bond, Ms. Helen?
Yes, Judge. So when I went and spoke to Mr. Lancaster, I did an Odyssey check for Ms. Bridges. This alleged accuser offered violence to Mr. Lancaster, and he was merely trying to protect himself. So yes, Judge, we are having a bond hearing because we're entering a plea of not guilty. And we've got some new information that I've learned on behalf of Mr. Lancaster. So yes, Judge, we are asking for a bond modification to a signature bond of the same amount, Judge. Again, because Mr. Lancaster is taking this case to a full jury trial. And we are asking for a signature bond so that he can fight this case on the outside. Again, because Ms. Tara Bridges, the alleged accuser, does have a history of violence. Just to go into the Ayala factors, Judge, can I have the pretrial read his history, please?
Ms. Harrison.
16 cycles with history in Georgia and South Carolina. Last arrest was February of 2018 for aggravated assault, aggravated battery, and theft by taking in Cobb County. He was convicted on the theft by taking, and the aggravated battery was amended to, aggravated battery was amended to a battery. He's currently on probation under case 1893166, 2 counts, possession of firearm by convicted felon or felon and first offender, theft by receiving stolen property, possession of marijuana less than an ounce, sentenced October of 2018, 2 years confinement, 3 years probation in Cobb County. Record also indicate a 2018 misdemeanor conviction for battery and theft by taking, a 2008 battery, and 2004 unlawful carry of weapon misdemeanor conviction in South Carolina. Nothing further to add.
And that's why I set the bond at $7,500, Ms. Helen. It will remain at that amount.
Your Honor, I just want to put on the record as well, this defendant has an open case against this same victim, 22 CP 211899, where he has a $55,000 bond, Your Honor, aggravated assault, family violence, battery of family violence, and possession of a firearm by a convicted felon, Your Honor.
All right. Mr. Lancaster, we will give you the opportunity to speak with Ms. Helen at another time. I see you there with your hand up. So you'll have that opportunity, sir. She'll give you a call, okay?
And Mr. Lancaster, let me let you know what happened. The judge made a statement that he is unwilling to make that bond modification for your history, okay? I'll give you a call.
Yeah, I was never convicted of theft.
Mr. Lancaster, let me give you a call, okay?
Okay.
Thank you.
All right. Who do we have next?
Position number 30, Mr. Carl Roberts from courtroom 2.
Okay. Is that?
You're muted, Your Honor. Everybody's muted.
Yes, give me a moment, please.
Okay.
All right, so we're gonna go to position 30, Carl Roberts, is that right?
That is correct, Your Honor.
It's gonna be a negotiated plea.
Yes, Your Honor.
Good morning, Mr. Roberts. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir. Good morning, Judge.
Good morning.
I apologize for interrupting you. I was looking at
It's
another.
gonna be a stay away issue. Is that right, Ms. Helen?
Yes, Judge, I apologize. This is non-negotiated and the stay away is the issue.
All right. Mr. Roberts, can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Thank you. Ms. King.
This is position 31, correct, Your Honor?
Position 30, I believe.
30.
Carl Roberts.
Yes, the offer is 12 months to serve 28 days, credit for time served 14 days with the balance probated, FVIP, no further contact, and a stay away. The stay away address is 901 Bolton Road Northwest, and the no further contact is with Anita Harrington, ANITA, last name HARRINGTON. We've been in contact with this victim. She stated they are married, but they share no children. She states that he has been violent with her in the past, and he was actually arrested in Virginia for choking her in 2020. The victim also states that she called the police about 4 months ago when he punched her in the face, but it did not lead to an arrest. The victim also states that she wants to file for divorce and wants absolutely no contact with this defendant, and she wants him to stay away from the residence. And she says he will need a one-time escort to retrieve his belongings. She's okay with that, but she is adamant about the stay away and no further contact, Your Honor.
Okay, thank you, Ms. King. Ms. Helen?
I have heard that. I also spoke to Mr. Roberts. They are both leases on that property, Judge. So it would be really hard for Mr. Robert to stay away from the property that he is a leaseholder of. So he would be homeless without that address, Judge. So they are both named on that lease. So we are asking for him to be able to return to that address to be able to reside, Judge. I have heard the victim, Anita Harrington's, through the state, Judge, but when I talked to Mr. Roberts, again, he has no place to stay. That is his main address that he resides at, Judge.
Miss Helen, I'm not going to put a man back into a home where the victim of a simple assault and a terroristic threats does not want him to be. So that absolutely makes no sense. So he's not, if he wants to take the plea, he's going to have to stay away from that house. He can go back there on one occasion, or that residence. He can go back there on one occasion with law enforcement to retrieve any belongings and find himself another place to be. But
Mr. Roberts. Do you, have you heard the judge?
Yes,
He's
ma'am.
willing- So are you able to find another address to reside?
I will.
Okay, so are you willing to accept the plea as time served with the balance probated in those conditions?
Yes.
Understood. He accepts, Judge, and the one-time escort, Judge, to gather any items that he may need from that address.
Okay. Mr. Roberts, it's my understanding that in case 22 CR 005865B, you wish to plead guilty to simple assault, family violence, and terroristic threats and acts. Is that correct?
That's correct.
Are you under the influence of any drugs or alcohol this morning?
No.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes.
Has anyone forced or coerced you to plead guilty?
No.
I will accept the plea as negotiated. Mr. Roberts, you are to stay, have no further contact with Ms. Harrington. And let me be clear what no contact means. No contact means no physical contact, no phone contact, no social media contact, no Twitter contact, no Facebook contact, no contact whatsoever. And you to stay away from that 901 Bolton Road address. You can go back to that address on one occasion with law enforcement to retrieve any belongings that you might have there. I'm going to waive the probation fees for you while you're on probation and help you get and stay on your feet, but you're going to have to be on probation for the entire 12 months, okay?
Yes, sir.
All right, good luck to you, Mr. Roberts.
Yes, sir.
Thank you, Judge.
Next, we have position number 3, Mr. Jesse Gray. Position 3.
Ms. McLeod, this is your case.
Yes, Your Honor.
And what are we doing with Mr. Gray this morning?
We're taking plea, Your Honor. It's a negotiated plea.
Okay, thank you. Good morning, Mr. Gray. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me? Do you swear to affirm the testimony that you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down, Mr. Gray. Mr. Dudley?
Yes, Your Honor, it's going to be 12 months to serve, 32 days, credit for time served, 16 days, balance suspended, and to stay away from the incident location, 135 Andrew Young International Boulevard, Northwest, the Waffle House.
That is correct, Your Honor. That is our understanding of the terms of the plea.
Okay. Mr. Gray, it's my understanding that in case 22 CR 005876Y, you wish to plead guilty to disorderly conduct and criminal trespass. Is that correct? Okay, courtroom 2, you're on mute.
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, sir.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I will accept the plea as negotiated, Mr. Gray. You know you can't go back to that Waffle House, right?
I won't step near it.
Okay, thank you. Good luck to you, sir.
You too have a blessed
Thank
day.
you, Your Honor.
Thank you. Ms. McLeod.
Next, we have position number 18, Mr. Harris Brown.
This is going to be an arraignment and a bond hearing.
That's correct, Your Honor.
All right. Good morning, Mr. Harris Brown. I'm Judge Eric Moore. This is the state all-purpose calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Can you raise your right hand for me? Do you swear from the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, you can put your hand down, Mr. Harris Brown. You've been charged in case 22 CR 001959Y with loitering and prowling, willful obstruction of a law enforcement officer, and possession of a pistol or revolver by a person under 18 years of age. Each of these charges carries with it a maximum penalty of 12 months in jail and/or $1,000 fine. Do you waive formal reading of the accusation, Mr. Ford?
Yes, we do, Your Honor.
How do you plead to these charges, Mr. Harris Brown? Guilty or not guilty?
Not guilty.
Okay, we'll record your not guilty plea and your case will be returned to the division judge. You'll get notification of your next hearing date. Do we have that bond? Thank you. Let's see, the bond was set on April 2nd. $1,000 for the loitering and prowling, $1,000 for the obstruction, and a $2,000 cash bond for the possession of a pistol by a person under 18 years of age. Is there a history, Ms. Harrison?
4 cycles, last arrest, April of this year, willful obstruction of law enforcement officers and possession of a pistol or revolver by a person under the age of 18 in Fulton County. Record does indicate open case pending for possession of marijuana with intent to distribute, possession of a pistol or a revolver by a person under 18, 22 CP 206934. Additional open case, theft by take-in, 22 CP 206935. Additional open case, loitering and prowling. I'm sorry, wait 1 moment. Additional open case for theft by receiving stolen property, 22 CP 209981. Open theft by taking, 22 CP 206936. Nothing further to add.
Mr. Ford.
Thank you, Your Honor. Your Honor, my client is presently a high school student. We're hoping to get his bond modified. I show on the loitering and prowl, I do show a signature bond on that. And also on the possession of a revolver is a $2,000 cash bond. We asked that be converted to a $2,000 signature bond. And also with the willful obstruction of law enforcement, that's a $1,000 surety bond. Your Honor, we're asking that be a $1,000 signature bond so my client can be released and continue his high school education. He does have, he's a lifetime resident, Your Honor. As you know, he was 17 years old. He has given me, he does have community support. He's given the telephone number of his mother. He has an address at this time, Your Honor. So because he's a high school student, Your Honor, we ask that those bonds be modified so he'll be able to attend high school.
So let me see, Ms. Harrison, what was the date of the first possession of a pistol?
One second. I have February 23 of this year.
February 23rd of this year. So, and then he got another one. So he was arrested in February for possession of a pistol. And then he was arrested
and then
again.
the other one is June 18th of this year.
I have an offense date of April 1st.
That's the present case.
That's the present case. And then the following open cases for June 19th, 2022.
Yeah, he has an open case 22 CP 209982 for a pistol.
I'm sorry, I'm a bit confused. February 23rd of this year, what offense was that?
That case number, that's possession of marijuana with intent to distribute and possession of pistol or revolver by a person under 18, 22 CP 206934.
So he picked that one up first, and then he picked another one up on April 1st.
Correct.
Okay, that's what I was trying to establish. And in the June, what was the June of this year charge?
June was theft by receiving stolen property, 22 CP 209981.
Okay, and so presumably because he received a second possession after he'd already received the first one in February, that's why Judge Law gave him a cash bond on that second one, because apparently he didn't learn his lesson the first time. So I'm going to leave the bond where the previous judge said it. Good luck to you, sir. Who do we have next?
Next, we're gonna go to position 35, Mr. Christopher Thomas.
And Ms. McLeod, is this your
I
case?
have, yes, Your Honor, but I haven't had a chance to discuss with Mr. Thomas his plea offer, Your Honor. I would like to get a chance to do that.
Okay, so can we have Ms. McLeod speak with, you have the number, Ms. McLeod?
No, Your Honor.
I think it's 4.
McLeod, it's the 40. I'll call Ms. McLeod. I'll call her.
Thank you.
Thank you.
Can we go to position number 6, Mr. Anthony Brown?
That's Ms. McLeod's case also.
They'll both talk to Ms.
To
McLeod.
talk with him either.
You need to talk with him also, Ms. McLeod?
I also need to talk with him, Your Honor.
Okay, so Officer Norris, can we just have, once she's done talking with the first one, can we have her talk with Mr. Position 6 also?
That is correct, yes.
And I also need to speak to position 10.
Okay.
I don't have position 10 in here.
Okay, because I've been trying since early to get that.
But I have in front of you, Your Honor, position number 29, Mr. Otis Ponder.
29, okay.
He's not mine, okay.
All right, this is a negotiated plea, Ms. Helen.
Yes, Your Honor.
Good morning, Mr. Ponder. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can put your hand down, Mr. Ponder. Thank you. Ms. King?
Yes, Your Honor. The offer is 12 months to serve 36 days, credit for time served 18 days with the balance probated, $800 in restitution, at ADET, no further contact and stay away. The no further contact is with Janique Ray, Janique, last name traditional spelling, and the stay away is from 2075 Donald Lee Hollowell Parkway Northwest.
That is our understanding of the plea, Judge. We accept it. We stipulate to the factual basis, venue, and ID. It's a probated sentence, so we ask for the probation fees to be waived. And if the state's amenable, can it be non-reporting after he completes the conditions?
Any objection, Ms. King?
The only issue we're having as the state, he has a lot of convictions, especially in the last 5 years. He has a criminal trespass from this year, another criminal trespass, drug-related objects, which is one of the charges here today from this year. The same 2 charges from last year, a criminal trespass from 2020. We're just concerned that he's not following the law. At this time, the state is going to request that he reports for probation.
Okay. Given the charges, I'm going to allow him to go non-reporting once he completes the terms, Ms. Helen.
Understood, Judge.
Okay, Mr. Ponder, it's my understanding in case 22 CR 005768Y, you wish to plead guilty to theft of lost or mislaid property and possession and use of drug-related objects. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You can represent it by counsel. Are you satisfied with your counsel's representation?
Yes, sir.
Hold on, yeah, hold on. Do you need to speak with Ms. Helen, Mr. Ponder? I just don't want you to say something that's going to get you into more trouble, okay?
Yeah, I would like to speak with Miss Helen over the phone.
Okay,
I'll give him a call right now.
okay. Well, I believe the phone's in use.
I got
Okay.
to call from another phone.
Mr. Ponder, is it about the plea? If it's any legal, we can talk about that as soon as I call courtroom 2. But if you agree to the plea, you want to go through with it?
Yeah, I agree with the plea.
Okay, well, then I'll call you after we're done. Judge, he's ready to go through the plea.
Okay. I believe my last question was, you've been represented by counsel. Are you satisfied with your representation, Mr. Ponder?
Yes, sir.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
I understand.
Has anyone forced you or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated, Mr. Ponder. I am going to waive the fees for you while you're on probation and help you get and stay on your feet. And when you complete the terms, it'll go to a non-reporting status, okay? All right. Good luck to you, Mr. Ponder.
Thank you. So I get released, right, today?
They'll release you in 48 hours.
Thank you very much.
Thank you.
Yes, ma'am.
Okay.
Position 15.
This is Mr. Edwards.
Yes,
Yeah,
sir.
Renee Rockwell is the private attorney. She's on the line for him.
Okay. Are you with us, Ms. Rockwell?
Good morning, Judge.
Good morning. How are you today? Ms. Rockwell, you are on mute and your camera's not activated.
Yes, Judge.
No, there you are. Good morning. How are you today?
Good, Judge. Thank you so much for this platform.
You're welcome. What are we doing with Mr. Edwards today?
So, Judge, the way I understand it, technically, Mr. Edwards is on bond for this matter. He's got other charges in Superior Court. We would ask the prosecutor to waive sounding of those charges. He is placed on the calendar simply because he's in jail, but he's not in jail on these charges. We've entered a not guilty plea. Does the prosecutor have a second to talk to me about what the latest and greatest offer was? We were standing by our not guilty, but I don't know if anything has changed.
I will put the offer in the chat for you.
Thank you so much.
No problem.
Ms. Rockwell, before you
offer in the chat.
Did you get that, Ms. Rockwell?
Yes, I did, and I was talking, Judge, on mute. Let me just, we are standing by our not guilty. Could we just return this to the courtroom, Judge, for trial?
Are you going to file a written waiver of arraignment, Ms. Rockwell? Otherwise, I'll have to arraign him this morning.
Oh,
She already did. She
Oh, he's
filed
already been
it
arraigned?
already.
Okay.
Yeah, she
All
did
right.
that a long time ago.
Okay.
Yeah.
So we're all right. So we'll return it to the division judge, and you'll get notification of the next hearing.
I'll be excused.
Yes. Have a good day. Good to see you.
Thank you. Thank you, Mr. Prosecutor. Appreciate it.
Let's see. Good luck to you, Mr. Edwards.
Thank you, sir.
All right. Who do we have next?
We're going back to courtroom 2, position number 35, Christopher Thomas.
And what are we doing, Ms. McLeod?
We are going to be taking a plea, Your Honor.
Okay. Good morning, Mr. Thomas. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Good morning, sir. Yes, sir, I do.
Okay, thank you, Mr. Thomas. Can you raise your right hand for me? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir, I do.
Okay, you can put your hand down. Thank you. Ms. King?
Yes, it's 12 months to serve, 36 days, credit for time served, 18 days with the balance probated, an 8-week anger management course, and a stay away and no further contact. The stay away address is 731 Peachtree Street Northeast, which is the Redeemer Church. And the person is Percy Jones. That is the no further contact. Percy, last name traditional spelling.
Ms. McLeod?
Yes, Your Honor. Those are the terms of the plea.
Mr. Thomas, it's my understanding that you wish to plead guilty in case 22 CR 005761G to battery and willful obstruction of a law enforcement officer. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, sir.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated. Mr. Thomas, I am going to waive the probation fees for you while you're on probation and help you.
Thank you, Your Honor. I was going to ask for that.
You're fine, Ms. McLeod, to help you get and stay on your feet. And is there any objection to non-reporting, Ms. King?
No objection, Your Honor.
Okay, and once you complete the terms of the probation, it'll go to a non-reporting status, Mr. Thomas, okay?
Yes, sir.
All right, good luck to you, sir.
Thank you, Your Honor.
Excuse me, Judge.
Yes.
Attorney Steele is on the line for position number 1. I don't know if the jail know where he's located at. She was just asking if she can go forward.
Norris, do we know where position number 1 is?
He's on the 7th floor. He's on the max floor right now, Your Honor. We have a officer that's roving from floor to floor.
Okay.
He's trying to get up there now.
Okay, thank you. So we'll be with you when we can, Ms. Steele. So who do we have next?
We have position number 6, Mr. Anthony Brown.
Okay.
Your Honor, my client will not be taking the plea today.
This will be an arraignment.
Yes, Your Honor.
Good morning, Mr. Brown. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir, I do.
All right, can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down, Mr. Brown. You have been charged in case 22 CR 005765F with criminal trespass, family violence, and harassing communications. Each of these charges carries with it a maximum penalty of 12 months in jail and/or $1,000 fine. Do you waive formal reading of the accusations, Ms. McLeod?
Yes, I do, Your Honor.
Do you plead to these charges, Mr. Brown, guilty or not guilty?
Not guilty.
We will record your not guilty plea. Your case will be returned to the division judge, and you will get notification of your next hearing date. Good luck to you, sir.
Thank you, Your Honor.
Welcome. Who do we have next?
Your Honor, I'm just waiting for the officer to get upstairs. He's on his way there now.
Okay. All right. Thank you. So let's see. While we're waiting we do have an 11 o'clock bench warrant reset. Let me just sound and see if anyone's here on that calendar.
She is on the line, Judge. I just spoken to her.
Okay. Is this Miss Gray? Is that you, Miss Gray? If so, you're on mute. And who's going to represent Miss Gray today? There you go. Can you hear me, Miss Gray?
Hi.
Good morning, ma'am.
Yes.
Okay, let me see if we have someone to represent you this morning.
Currently, there is no one to represent me this morning.
Hold on, Ms. Gray. We have public defenders that are present, and we'll have one of them speak with you if that's what you would like. Mr. Ford?
Yes.
Miss Helen has Miss Gray.
Okay, all right. So you need to speak with Miss Helen?
I do, Judge. If I can get a breakout room.
Okay, if we can put Miss Gray and Miss Helen in the breakout room, please.
And Your Honor, if Mr. I think it's Londe Lanoy is available, I'd like to speak with him. I've tried to call and no response.
Okay, it's a little before 11, Mr. Ford. I don't see him on the line as of yet, but we still have 15 minutes before he's required to be here. So as soon as he comes on the line, if you're available, we'll put him in a breakout room.
All right, sounds good. Thank you, Your Honor.
You're welcome. Let's see, I guess we'll be in recess until someone returns.
Your Honor, did
Yes.
we deal with position 7?
No, we still have a number of people, I believe, that we need to deal with.
Okay.
So the jail, I believe, is having to go from floor to floor to.
Okay, all right. Thank you, Your Honor.
All right, you're welcome. Yeah, there are a number of people that we still need to deal with.
Okay.
Your Honor, position number 7 is in Cobb County. Let me see if they brought him over.
Okay, thank you.
Give me 1 second.
Position just for FYI, 1, 7, 10, and 21. Check my count. 10. Yes.
Okay, yeah, give me 1 second. I'm going through it right now. So 1, 7, 10, and 21. Is that what you have? Okay, thank you.
Your Honor, position number 7 is in downtown. He's downtown for it.
Position 7.
That is correct.
Downtown, so he needs to be reset.
Judge, this was the second reset that we did on it because he was downtown last time at Cobb. And I think they made a note of that and they said they were trying to get him over for this calendar.
Okay, so it's apparently a time served, please. So is this your case, Mr. Ford?
Yes, it is, Your Honor. I did speak with Mr. Brown yesterday in Cobb County. It appears a reset will be good because he has stated to me that he has a private attorney, Mr. Isaiah Gregory. And I don't see Mr. Gregory on the line right now. And I feel a little uncomfortable going forward.
Well, he's not here, so we won't be able to go forward. So when do you want to reset him until?
We can just sit 1 week, Your Honor, and maybe he can get a hold of Mr. Gregory.
I actually know Mr. Gregory would, I mean, we're resitting him. I can give him a phone call nonetheless, though.
Okay, that'd be great.
Well, but Mr. Brown's not here, so we're gonna
Right, but I'm just saying, I don't want to resit him to a date that Isaiah is not available for,
Oh,
so.
okay, all right. So can you call him now, Mr.
Yeah,
Walker?
if I could just have two seconds, I'm
Okay.
pretty sure I can get him on the line.
All right, thank you.
this afternoon.
And I'm sorry, Your Honor, what's the defendant's name?
Larry Brown.
Larry Brown. Okay, 1 second.
Okay.
So, so hold on, Your Honor. So I know this is kind of weird, but I have Mr. Gregory on the line, and he says that Mr. Brown has a felony trial tomorrow in Fulton. So I don't think Tuesday would be a good day for a reset.
Okay, so 2 weeks. When does he want to reset it for, Mr.
What do you
Walker?
want to reset it for, Mr. Gregory? Okay, that's fine. I'll talk to you later. He said Tuesday is fine, but like I said, he has a felony trial in felony court tomorrow. So he said he'll let the court know the outcome of his felony case on Tuesday, I guess.
Okay, so we'll reset it for, what's that, 9/20 next Tuesday?
Yes, Your Honor, thank you.
Okay,
You already got position number 1 ready for you.
okay. And this is Ms. Still's case.
Yeah, here in medical.
Okay, what are we gonna do with Mr. Alford this morning, Ms. Still?
Your Honor, is if this is a first appearance, we would just enter a not guilty plea. Mr. Alford is in custody on other charges with no bond at this time. So no matter what Your Honor does, it's going to be until we resolve that matter.
Okay, do you want to follow written waiver of arraignment, or do you want me to have him arraigned this morning?
Whatever's most expeditious, Your Honor. You can go ahead and arraign him.
Okay, that'll be fine. Good morning, Mr. Alford. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Okay, can you raise your right hand for me, Mr. Alford? Do you swear affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Thank you, sir. You have been charged in case 22 CR 005652E with 2 counts of terroristic threats and acts. Each of these charges carries with it a maximum penalty of 12 months in jail and/or $1,000 fine. Do you waive formal reading of the accusations, Ms. Steele?
We do, Your Honor.
How do you plead, Mr. Alford? Guilty or not guilty?
Not guilty.
We'll record your not guilty plea. Your case will be returned to the division judge, and you'll get notification of your next hearing date. Good luck to you, sir.
All right, thank you.
All right. Anything further, Ms. Steele?
No, thank you.
Have a good day.
Judge, give me 5 minutes for position 21.
Okay.
And Judge, we're ready on the bench warrant, position 1.
All right. Let's see, who's handling this for the state?
Position 21, that would be me, Your Honor.
Okay. Ms. Helen?
Right,
Yeah.
It's not position 1, is it? You said,
I'm sorry.
Oh, the
Position,
DV calendar?
yeah, it's
Oh,
not
I thought it-
position 21, Delaney.
Oh, position 1 DB, that's still me, Your Honor.
okay, so this is gonna be position 2 on the DV calendar, Ms. Gray.
Okay.
Okay, all right.
Yes.
Ms. Helen?
Yes, Judge, we're asking for this bench warrant to be set aside. When I went and spoke to our client today, the address that's listed on Odyssey was the same address she was ordered to stay away from in May. And that address wasn't updated until September. She didn't realize it was still the same address from that case she was ordered to stay away from. So she didn't receive the notice in August because it went to the original address. In September, she has updated to the Garnett Drive, Douglasville, Georgia, has a good phone number, has a good email. And again, Judge, her intention was not not to come to court as she's present here today. So we are asking for you to waive and remove this bench warrant. She understands to come to all court appearances because this case is still open. And we will not have any further failure to appears because that is her address going forward, the Douglasville, Georgia address.
Okay, Ms. King.
Yes, the state is requesting that the bond remain in place due to the violent nature of the offense and the defendant failing to appear. This defendant has a conviction from 2018 financial transaction card fraud, which is a crime of moral turpitude. For that reason, while we understand the defense's contention as to why she didn't come to court, but the defendant has been known to lie in the past. Again, this is a violent offense, Your Honor, and for that reason, the state feels it's reasonable and necessary for the bond to remain as set.
Okay, and Ms. Helen, we do have a correct address at the present time. Is that what you're telling the court?
Correct, Judge. 157 Garnett Drive, Douglasville, Georgia, as well as the up-to-date phone number and email address.
Okay, Ms. Gray, is this court's practice to give defendants one time to miss a court date? You have now used up your one time. I will set aside the bench warrant on this case, but if you miss any further court dates, your warrant will not be set aside in the future, okay?
Understood, Judge.
I want to make sure she understands. Okay, you're on mute, Ms. Gray. Ms. Gray, you're still on mute. I can't hear you. Okay, did you?
It's not Garnett Drive, it's Garrett Drive. Garretts.
Okay, did you get that, Ms. Helen?
I did, Judge. 157 Garrett Drive.
Is that correct, Ms. Gray?
Yes, perfect.
All right. So as I said, this is your one time to miss court. If you miss it again, the bench warrant will not be set aside the next time. Good luck to you, ma'am.
Thank you, Judge.
Let's see, it's almost 11. Has Mr. Flournoy joined us? Okay, well, he still has 2 minutes to log on, so.
And Judge, is she able to be excused today?
Oh, yes. Have a good day, Ms. Gray.
Thank you so much.
Okay, let's see, court will be on recess until someone returns.
There's other defendants coming online now for the hearing for the DV county.
Okay, thank you. Mr. Flenoy?
I don't think he's connected yet to the sound. You may have to log back on because I didn't see it.
I apologize. Did you call me, Judge?
No, Ms. Helen.
It had to come through yet.
It has? Okay. Because I did it from my phone, it might be.
Your Honor, seems like Mr. Flenoy is on. Oh, no, he's gone.
I just spoken to him to relog back on it to accept the auto and mute. He's having difficulties right now.
Right, thank you.
Mhm.
All right, Judge. '21.
Okay. So this is Mr. Honeycutt, is that correct?
Yes, sir.
Good morning, Mr. Honeycutt. I'm Judge Eric Morrow. This is the state all-purpose calendar. Let me first advise you have a right to remain silent. Anything you say can be used against you. You have a right to have an attorney present at these proceedings. We have provided you with the opportunity to speak with a public defender to represent you. It's my understanding that you did not wish to speak with the public defender. Is there a reason for that, Mr. Honeycutt?
Oh, Judge, that was my case when I went and spoke to Mr. Honeycutt. He would like to move forward pro se so that he can issue and accept that plea, Your Honor, through the public defender's office. I do not believe it's in his best judgment to do so, but he would strongly like to take that plea that is being offered from the state and would like to do that pro se, Your Honor.
Okay. So, Mr. Honeycutt, you've been charged in case 22 CR 001813J with 2 counts of battery family violence and 1 count of cruelty to children in the 3rd degree. Ms. King, what is the offer in this case?
It is time served 163 days and no further contact and a stay away. The no further contact is with Sharonica Lewis, Sharonica, last name traditional spelling, and the stay away is 1347 East Washington Avenue.
Let's see, is there a history, Ms. Harrison?
Let's see. 20 cycles. Last arrest was March of this year for aggravated assault. Record indicates an open case for ag assault with a deadly weapon, 3 counts, possession of firearm during the commission of a felony, 3 counts, simple battery, family violence, possession of firearm by convicted felon. That is an open case, 22 SC 181187. Also, there is a probation violation in 222. One moment, Judge.
While you do that, Ms. Helen, could you come back on for me, please?
Yes, Judge.
In speaking with Mr. Honeycutt, you advised him regarding these open cases and how a guilty plea might affect him as he goes forward.
I did, Your Honor.
And and you understand that, Mr. Honeycutt, that if you plead guilty to these 2 family violence cases, that might affect if you're on, not only if you're on probation, but any cases that you have that are currently pending. You understand that?
Yes, sir.
And it is your desire to still, Ms. Helen, just before you go.
Understood.
And those other cases, are those cases holding him in?
That is correct, Judge.
Okay. So do we know what the bond is on those other cases?
I do not, Your Honor.
So you have been advised, Mr. Honeycutt, about that if you plead guilty to these charges, that it could affect those other charges. And just because you plead guilty to these charges today does not mean that you're going to be released from custody. Do you understand that?
Yes, sir.
Okay. And do you still have a desire to move forward with a guilty plea in with these 3 charges today?
Yes, sir.
And Judge, I would ask again, if he wants to plead guilty, a NOLA would also be his best interest if he were to do that, if it would be agreed and accepted.
Your Honor, he has no bond on the felony case.
Okay. Ms. Harrison, I'm sorry, could you tell me what his history is prior to these charges were March?
Yes, Judge. He has a conviction. Yes, he has a 2018 conviction for possession MDMA under case 18 SC 157392. He has a guilty conviction for 2016 burglary in the 2nd degree, criminal damage to property, 2nd degree entering auto, possession of tools, and theft by taking. That's a conviction in Fulton County under 16 SC 144545.
Okay. Let's see, have we gotten him? Thank you, Ms. Harrison. Have we, I'm not going to allow him to use a NOLA, Ms. Helen, given his history. Ms. King, have you been able to provide the jail with the paperwork for a plea this morning?
No, Your Honor, I can do that quickly.
Okay. Is it 5 North, you all have a place that you can receive that paperwork?
No, this is the floor. So,
Okay, so let me he's been held on other charges. It's not paramount that we take a plea in this case today because he's not going to be getting out regardless. So I think what I prefer to do is to reset this so that you all can get him the paperwork prior to the next court hearing.
Who do I send the paperwork to?
I'm sure PD Helen has the paperwork, Ms. Gunn.
Oh, okay.
Oh,
Are we discussing plea paperwork?
yes.
Do you need plea paperwork, Ms. Helen, or do you have your
It's
own?
my understanding he's pro se.
Correct.
Oh, he's pro se.
Right. He's going pro se, Mr. Walker.
Oh, I'm sorry, I take that
Yeah,
back.
he's taking the plea against Attorney Helen's advice.
Oh, got it.
So, but these charges are not holding him in. So what I think that I prefer to do is get the plea paperwork together and have him have it all ready by the next court date.
Should we send that to Officer Deputy Norton or?
McGregor or?
5 North, who should we send the paperwork to when we do get it together?
You send it to Norris.
Norris, okay.
Okay, that's what I meant. Okay, we can do that.
All right, so I'm gonna reset him. I would prefer to see him and take that plea myself. And as I said, I won't be doing the SAP calendar next week. So can we reset him for the 27th? And have that paperwork filled out by the 27th so that we can go forward at that time?
Yes, Your Honor.
Okay, does anybody have an objection to that? Okay, so Mr. Honeycutt, I'm willing to take your plea, but I'm going to have to reset you, so I'll see you back here on the 27th to take that plea, okay?
All
right, we'll see you back then, sir. Thank you. Okay, who do we have? Who else do we still need position?
We got position 10 in courtroom 2, Your Honor, Mr. Claxton, position 10.
Okay.
Your Honor, before you do position 10, is okay if you could put Mr. Flannery and I in a breakout room?
Okay.
Yes, I can do that at this time.
Okay, thank you.
Thank you, Your Honor.
And this is Ms. McLeod's case. Ms. McLeod, do you still need to speak with
No, Your Honor, I've spoken with him already.
Okay, and what are we doing? Say it again.
We are going to be taking a plea.
Okay, thank you. Good morning, Mr. Claxton. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes. Sir.
Thank you. Can you raise your right hand for me? Do you swear from the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Thank you, sir. Mr. Dudley?
The plea is going to be 12 months to serve, 32 days, credit for time served, 16 days, balance probated, 4 weeks of anger management, and no further contact with Tamika Willis. Nothing further from the state.
Okay, Ms. McLeod?
Yes, Your Honor, that is my understanding of the terms of the plea.
I'm going to waive the fees. Any objection to non-reporting may complete the terms.
No objection.
Okay.
Thank
Mr.
you,
Clark,
Your Honor.
you're welcome. Mr. Claxton, it's my understanding that in case 22 CR 0058770G, you wish to plead guilty to simple battery and simple battery in a public transit vehicle or station. Is that correct?
Yes.
Are you under the influence of any drugs or alcohol this morning?
No.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes.
You understand that you have a right to a trial by jury on these charges and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes.
Is anyone forced or coerced you to plead guilty?
No.
Okay, I'll accept the plea as negotiated, Mr. Claxton. I'm going to waive the probation fees for you while you're on probation to help you get and stand on your feet. And when you complete the terms, it'll go to a non-reporting status. So as soon as you do the 4 weeks of anger management, the sooner you'll be non-reporting to probation, okay?
Okay.
All right, good luck to you, sir.
Thank you guys so much.
Oops, I'm sorry.
You're welcome.
You're welcome.
Thank you, Your Honor.
Okay, I think that we are now waiting for Mr. Ford to return. Have we And I also believe that we completed everyone on the 9 o'clock SAP calendar. Did we miss anybody?
You go with Matthew, you said on what?
Say it again. Thank you. Have we missed anyone? Okay, so I think we're done with the 9 o'clock calendar courtroom too. Thank you. I'll see you all this afternoon. Do you have this paperwork? Yes. Mr. Marshall?
Your Honor, courtroom 2 is completed. May we be excused?
Yes, I'll see you this afternoon. Thank you.
All right, thank you.
All right.
To confirm, position 1 from the DV calendar has not logged on, correct?
No, they're in a breakout room.
Oh, gotcha. Thank you.
At the present time. So we will be in recess until Mr. Ford comes back. We will handle his case, and then we will go over the calendar for today, okay?
Thank you, Your Honor.
All right. We'll be in recess until Mr. Ford comes back. Miss Helen, are you there?
Yes, Judge.
Do you know whether position 21, Mr. Honeycutt, do you know whether or not he has a public defender for the
I do not believe he's been assigned a public defender at a Superior Court judge.
is there any way that you can find that out for me?
Sure, I'll check and see if anyone's been assigned to his
You don't-
case.
Okay, you don't have to do that. I just want, if he does, or if there are assigned, before the next 2 weeks, I would like for that attorney to know what he's about to do in this court.
Right, sure.
Okay, so if you can reach out and follow up with that for me, I'd appreciate it.
I can, Judge. Thank you.
Okay, thank you.
Judge, this Miss Thomas.
Yes, Ms. Thomas.
We're done with me. Oh, do you want me to go ahead and call them, let them know they got a case, the DV case coming up, just in case, the probation? Oh, I can sit tight until, don't make it.
No, I don't think we're gonna need probation for the DV case.
No?
Yeah, so I think you're free to go.
Okay, well, thank you. You have a good one.
Okay, yeah, have a good one.
Bye-bye.
Thank you.
Mhm.
Your Honor, we're back with Mr. Lenore.
Okay. And so go ahead, Mr. Ford. What's the issue?
The issue is that he is a college student. He's a junior at Georgia State, and he did have a new address that the mail did not get to him, Your Honor. I did let him know that it's his responsibility to make sure his current address is on file. He did say that he did change to his new address of 3579 Meadow Glen Village Lane, apartment B, here in Atlanta, Georgia. I do have a telephone number for him, also an email address. He's a lifetime resident of Georgia, Your Honor. And like I said, he's a student now. He's a junior. And so we're hoping that you could set aside the bench warrant so he can pursue what he's doing right now. And he is informed me he is not going to miss any more court dates, Your Honor.
Okay. Mr. Walker, what did he miss?
It looks like he missed 1 second, because he has multiple cases at this point. It looks like he missed a final plea calendar. The only issue is, give me 1 second. So first off, he has 2 cases. So while he was out on bond on this case, he went and got another battery case. He also FTA'd in that case and got that bench warrant set aside. Presumably because it wasn't a family violence case, the clerk's office just set aside that bench warrant. But outside of that, in this case, where he updated his address, he put down the same address that he was ordered to stay away from. So now I know that PD4 has now since provided a new address, but just let me get my dates correct, because I don't want to misquote anybody or misquote anything.
And while we wait for Attorney Walker to come back, there are actually 2 open cases, Your Honor.
Yeah, there's 2 open cases. Just on last week, he put out an affidavit in the clerk's office. You can pull this up, Your Honor, and put down the very same address he was ordered to stay away from. So obviously that's indicative of that he's been residing at the address for the last year where he was ordered to stay away from. So at this point, he's reoffended. He's bench warranted on the other case that he reoffended on. And then he provided the same address last week as to his updated address where he was ordered to stay away from. So we adamantly are opposed to the bench warrant being set aside, and we ask him to remain into custody.
Let me see, Mr. Walker, can you pull up the bond on this case? And Mr. Flournoy, I see you with your hand up there. I'm gonna let Mr. Ford speak with you regarding this, so you'll have an opportunity, but okay.
Yeah, that address, it was my mom's house, but That's
Okay.
where I get my mail sent to. I'm not over there. I'm at the new address I gave to Mr. Ford. Just kind of.
Okay.
I have the bond order put up, Your Honor, and it's the same exact address. It was
Okay,
signed by Judge Law.
so put that on, put
I
that
can't
on.
use the address.
Hold
for,
on, hold
mail?
on, hold on, Mr.
Hold on,
Fenor.
Mr. Fenor.
Okay, I can only hear or one person at a time. So Mr. Walker, if you will put on the record what it says, the complete bond order.
Yes, it says no further contact with the victims, Anaya Taylor and Janice Durham, a stay away from 5500. I want to say this is Oakley Industrial Boulevard, Fairborn, Georgia, no weapons or firearms, which is the very exact address that he put on the set-aside request last Tuesday of this month. And that was ordered back in, I'm sorry, I have so many screens open at this point. That was ordered.
This is from Ms. Gray.
December 31st of 2020.
Okay.
By Judge Law. And just to make things worse, he's reoffended with another battery case, FTA'd in that case, and had that bench warrant set aside as well. And I
And
got
then he
that
reoffended
case
again
number.
in another state court case. So he has an open felony and an open state court case in addition to the case before, Your Honor.
Okay, so now, Mr. Ford, what address did you have down that? He says he's at?
I just spoke with Mr. Fenori. He has 3579 Meadow Glen Village Lane, Apartment D, Atlanta, Georgia, 30340.
Okay, and Mr. Walker, you were saying something about somebody else set aside.
I can give you the other case number, Your Honor.
No, just you don't have to give me the case number. Just give me the when it was set aside, who set it aside.
September the 6th, and it was a battery, but because it was not a battery family violence, the clerk's office set it aside. You know, they only put the family violence on these type of calendars.
Right.
The other types of charges, they'll just set aside.
And so what you're telling me is that at that time, on September 6th, he gave the address of 5500 Oakley?
On that set-aside request, yes, and on this set-aside request. He put down that address on both set-aside requests. Only this one is coming in front of the court because it's family violence.
Okay.
The other one was set aside strictly by the clerk's office. But yes, on both affidavits, he put down the same address that he was ordered to stay away from. And all this is viewable in Odyssey.
All right, that's a problem, Mr. Ford, right?
Well, what I heard from my client is that's an address he wasn't staying there. He was actually, that was the only address where he was getting mail at the time. And since he was a student, he was kind of transient. And so at this point, he stabilized his address with the one I just gave to you, Your Honor. But he was only getting mail there. He wasn't staying.
Well, who lives at that address? Does this Miss Taylor and Miss Durham live at that 5500 address?
No.
No?
I don't think so. I think he said it was his mother's address.
That's my mother's address. He's correct.
That's not my understanding. It's my understanding that the victims do live there, but nonetheless, at this point, on two affidavits that you have submitted, you have put that down as your address, and you've been ordered to stay away there since December of 2020.
I'm not down there, and I don't never go down there since 2020.
I'm not talking about.
Okay, hold on. Mr. Fenori, you need to remain silent because anything you say can be used against you. I agree with Mr. Walker, Mr. Ford. This doesn't make any sense that you're getting your mail somewhere where you're not allowed to be. So that flies in the face of logic because that doesn't make any sense to me.
But I guess what I'm hearing, Your Honor, that the two complaining witnesses in the other cases don't stay there.
It doesn't matter. He's to stay away from that address. He's been ordered to stay away from that address. And that means, I would imagine that I'm not going to have to say now, and you can't get your mail there. You know, that doesn't, because if you have to stay away from that address, that means you just can't be at that address. Right?
Yeah, like I said, Your Honor, and I'm trying to look at the information that I have up here, but it appears it might have been something that happened at that address, but the complaining witnesses did not stay there. Now, I know the order might have said to stay away from that location, but at this point, he did say he was only getting mail there so he could, and the victims, or not the victims, but the complaining witnesses were not there.
Okay.
That's a moot point. The order is the order of the court. He was to stay away from that address, and at this point, he is reoffended with the second battery case. He's FTA'd on both of these cases. For both of these cases, he has filled out a set-aside request and put down the same address on both affidavits that he was ordered to stay away from back in December of 2020. That is a direct indication that you have been residing and been returning to that address. Even if it was for the purposes of getting your mail, how are you getting your mail if you're not returning to the address? You literally have submitted a signed affidavit to the clerk's office on 2 different cases that's your address that you were ordered to stay away from. And you've FTA on both cases. The other case is not in front of the court because it's just a battery. This is a battery family violence. That's why we only have 1 case in front of the court. But I mean, at the point that you reoffended with another battery, you FTA on that case, you FTA on this case, and then you a request with the same address that you ordered to stay away from.
We got you, Mr. We got you, Mr.
Like I'm baffled. Like
I hear your frustration, and I don't disagree with you. Okay, so I think that's a problem, Mr. Ford. What I would like to do is I want you to speak with your client regarding the direction that this is going, Mr. Ford. Does he have any verification that he lives at 3579?
Meadow Glen Village.
And I want you to speak with him about that. I also want you to speak with him about, Mr. Walker, can you put the offers in the chat so that he knows? Because at this point in time, I'm leaning towards not withdrawing this bench warrant. So I want him to know what, if he has some verification that he can get to you that he actually lives at this address, then I'm happy to consider that. And Mr. Walker, I'd like for you to put in the chat to Mr. Ford what the offer is for these 3 charges.
Yes, Your Honor.
Okay. All right.
How do you go back to the breakout room? Anybody?
Yes.
Once I get the offers, Mr. Funori, then we can talk about those.
Oh, you in here with me? You talk now?
No, not now, but just give me a moment. Mr. Walker is scheduled to send me the, excuse me, the offers.
Tell her I don't have it, but I can bring it. I'll be here in the morning. Can she come back? Can she come by in the morning?
All right, we can go into the breakout room now, Your Honor.
Okay. So if you'll go back into the breakout room, And Mr. Ford, if he does have something, a utility bill, something that'll verify this address that you're telling me about, I'm happy to consider that before I make my judgment, okay?
All right.
Roland, thank you. We'll be in recess until Mr. Ford and Mr. Flynn come back.
Your Honor, we are back.
And Your Honor.
And I took the time, Your Honor, to email both you and Mr. Walker, Mr. Flenore's lease agreement.
Well, that lease that you sent has expired, Mr. Ford.
Your Honor, I'm so sorry to cut in. I'm trying to be patient, but you literally can't make this up. I'm gonna give you this case number because this is a third case apparently. I'm sorry, 21 CP 197363. If you look at the warrants on that case, that occurred February the 6th of 2021, same exact victim, same exact address. We have heard this defendant say that these victims do not live at their address, that he does not live at their address. I have a very hard time believing that, seeing how he has 3 cases with the same victims at the same address. And obviously February the 6th, 2021 is a subsequent date from the initial bond order on this case that was ordered in 2020. This defendant has violated the stay away order repeatedly and then put on 2 different affidavits that that's still his address as late as last week. You can look at the warrant on that CP number, which I found on the jelly screen, and it's the very same exact incident date. Incident location. So what this defendant is saying is an outright lie.
Your Honor, my client.
And that's outside the lease being expired, because at that point, I didn't even look at the lease because the warrant speaks for itself. The cases speak for itself. You don't keep getting arrested with the same victims at the same address if you're not returning to the address.
Can we get your client back, Mr. Ford, so that
he's not, I think I see him.
Oh, that's him down. Okay, I just want to make sure that he's with us.
And for what it's worth, obviously in that felony case I gave you, a condition of that bond was to stay away from the same address because it was the instant location. So,
okay. All right, Mr. Ford. Anything further?
Well, Your Honor, my client made it very clear to me that it was just his mother that would call him and say he had mail. He never said he went back to that address. I didn't take a look at the lease. He said he had a lease that was dated March that he sent me, and I forwarded on to both of them. My client is staying at a different address, that 3579 Meadow Glen Village. That's where he's getting mail, and that's where he's staying.
All right, and I appreciate that you sent me that lease. It was a limited lease that lasted only 2 months, I believe, for some reason. It had a execution date and an expiration date.
Okay. I didn't look at it in detail. I just thought it was the lease, Your Honor. I just wanted to get it to you quickly.
I appreciate you getting that.
As proof of his address. I'm prepared to talk about the offer that Mr. Walker has made.
Okay, all right. Go ahead with that, because you're between a rock and a hard place with setting aside the bench warrant this morning.
And to be honored, the state is rescinding its offer based upon the new information I just found out about his new felony case with the same victim. At this point, it's 12 months to serve.
Okay, but these cases, these cases occurred first, Mr. Walker. Can't we just let them handle those down the road? If he's picked up additional charges, these were the first ones, and they are first in line, and the way the court looks at it.
But my concern at this point is that the defendant has made clear that he does not follow the orders of a court. And that's something I look at, or I think that's something that the court should look at when we place people on probation, because that's the order of the court. So if you violated multiple bond conditions, in my head, you're not the best candidate for probation, with all due respect. And he has, at this point, violated 3 different bond conditions from 3 different judges. So why would you think that?
But he's not getting just probation. He's getting jail time also. And if he violates the probation, like you believe that he will, then he'll have to come to that judgment at that time, right?
Yeah.
I mean, the state's gonna have to do what the state's gonna have to do. I will, as a, as the ultimate senator, take into account what you initially presented. I don't even know if Mr. Ford wants to entertain a plea at this time. But Mr. Ford, what were you gonna say? I'm sorry.
Well, I was gonna say that my client was willing to do the time served. He's got credit for 11 days that he's already spent in jail. The state's initial offer was 60 days, which would be 30 days, which they're asking for him to do an additional 19 jail days. But based on his situation of being in school, I don't think this is a person who, and I know Mr. Walker wants to be someone that is continuously violating court orders, but I don't think that's the case here. I think this is a case of misunderstanding. His mother was the one that was calling him to say you had mail. He was having no contact with the complaining witnesses. And so at that point, I don't believe, then he let me know that the second chance bail bonds did not let him know about his court date. They think they contacted his father, and they did not, the message did not reach him. And so that's why he missed the second court date. This is not a person who's intentionally, I know Mr. Walker is looking at some things and saying, oh yeah, he's a person who is not trying to abide by the law, but I think it's the opposite. Here's a person who's a junior in college, who's trying to do the right thing. He's been working for a moving company since the summer, lifetime resident of state of Georgia, and his birth date would put him about 21 years old. Here's a person, I don't think it's time to throw him to the wolves at this point. I think this person is a productive member of society with a job, going to school. Your Honor, we're asking that you accept time served on this case. He has no problem doing the family violence intervention program. Definitely no problem with no further contact. He understands what that definitely means, and the stay away as well.
Your Honor, if I may, the defense has just stated that he called his mother called him, and he's been talking to his mother. His mother is the victim on the felony case and the open state case, Your Honor. He's not supposed to have contact. And defense has just testified, put on the record that he has been speaking and having contact with a victim in the subsequent cases before Your Honor.
Hold on. What are you saying, Mr. Lunde? I will give you.
My mom, she just calls me with mails. We haven't really no extra conversation. I work at the moving company, like you said. So me and my mom, I'm in Doraville and she's in Fairburn. I don't even have a car. So the trip down there would probably cost if I even thought about going to that address. And I'm only 21. I can't hold a grudge with my mom. You know what I'm saying? We made up over the phone. I still don't see her, but I'm glad I was homeless too before I was homeless. That's why I had her mail going there and mail going to my dad's house because I was staying with both of them. So if he understands, he understands.
And I'll just say that they were having more than phone conversations because on February the 6th, a felony warrant for battery family violence was taken out for the same victim.
My address is on file probably, just like it was.
I'm just saying.
Hold on, Mr.
It was at the same instant it was at the same instant location with the same victim. And that's why there's an open felony case. So there's clearly more than conversations going on. Even for sake of argument, if it was just conversations, there was a no contact order. And I don't want to be repetitive. That's why I feel like he's not a great candidate for probation because we have 3 cases, same victim, same instant location, and he's violated every order that's been issued by the court thus far. I will let Ms. King give the factual basis to this case as to why the state's offer, why I believe that, the 12 months is appropriate. She is more familiar with this case. However, I did want the court to be put on notice that this defendant has 3 cases with the same victim at the same instant location after being ordered that not to have any contact or not to return to that location. But with that being said, I'll let Ms. King give the factual basis, Your Honor, for the non-negotiated plea.
Yes, Your Honor, this offense occurred on December 30th, which was a Wednesday. Officers were dispatched to a domestic dispute. Upon arrival, they met with his mother, Miss Janice Durham, and she states that her son, the defendant, and Anaya Taylor were involved in a physical dispute in his room. She was standing in the hallway at the time, and she had her foot in the door. And she said that when she was in her room sleeping, she heard them yelling, and then she heard loud thumping as if someone hit the floor. At that point, she went to go check and diffuse the situation. She told the victim at that time to leave the home to cool down. She also stated that she heard her son say, "Fuck the police, get out of my house," to the victim. And she said she also heard him make verbal threats about the police. And at that point, the defendant pushed forcefully and smashed a hand in the door. But he said only the foot was struck at that time. At that point, the defendant balled up his fist and took a fighting stance as if he was going to fight the officers, which is where the obstruction charge came from, and he was taken into custody. He didn't want any kind of medical treatment, but the officers were able to get in contact with the victim in this case because she had left the scene due to the mother telling her to leave. And she did confirm everything that the mother told the officer about how violent the defendant was being. Now, going on to the other case, the other open case that occurred on July of—
I object to the other open case. We're not dealing with that case here. We're dealing with only the three that
That's
okay.
fine.
That's the second. That's the case involved in the global resolution. That's the second case involved.
I don't think they want to plead to both cases.
I'm objecting. I'm objecting.
Okay.
We're on the same page.
Okay, so let me just, Miss Lewis, are you with me? Did you just?
I am.
Okay, so you just sent a message out regarding another case in 913. Is he supposed to be in court today in Judge Besson's courtroom?
The other case is Judge, I see that Judge Besson, case manager, she set that one aside, and that one's supposed to be supposed to be scheduled, but she doesn't have on a thing. I thought they had 913 for this one, but she from the
I already called the chambers.
cases together.
I called Judge Besson's chambers and it was reset further notice, and that's how I found out about him being FPA on the other case.
Yeah, but Aisha has an issue out the warrants on him.
Right, because they did a reset. I mean, they did a set aside on the other case, which is what I said earlier, because that case is just a battery. It's not a battery family violence. And as you know, they only bring battery family violences back in front of the court for set asides.
Yeah, and the address that you said, the affidavits that he filled out on both of the cases with the same address of Oakley.
Okay, all right. So thank you for that clarification. Anything further, Ms. King?
Yes, just that battery case, that actually should be a battery family violence because the victim is his mother, and the state reserves its right to amend that accusation appropriately.
Okay. Mr. Ford.
Thank you, Your Honor. As you can state, and my clients had an opportunity to speak on this matter to a limited nature, this is not a person who should be looking at 12 months to serve. This is a person who's doing positive things in his life, Your Honor. And the issues, I think, are compounded by the fact that I believe somebody wants to have contact with him. So at this point, Your Honor, we're asking that the original offer, 60 days to serve, be reduced to just time served, be 22 days, credit for 11 days. He will do the family violence intervention program, and he will definitely understand the no further contact and stay away.
Okay, so this is what I'm going to do today. I am not going to set aside the bench warrant in the matter, which is what we are here on for. So the bench warrant will not be set aside. As such, if he doesn't move the case forward today, he is going to have to turn himself in. If he wants to plead today, I will accept the initial recommendation of the state, which is 12 months to serve 60 days, credit for time served 11 days, balance probated, family violence intervention program, and no further contact and a stay away. And if he violates the no further contact and the stay away, or doesn't report to probation, then we'll take it up at that time. So those are his options today, Mr. Ford. Do you need to discuss that with him?
Yes, I do, Your Honor.
Okay, so let's put them back into a breakout room, and that will, if that goes forward, that'll be obviously a non-negotiated plea. But that's that will be the sentence of the court in that regard. Okay, so if we can put Mr. Ford and Mr. Flournoy back into a breakout room, please.
Judge, y'all want to go over the calendar?
No, because Mr. Ford likes to be present to go over the calendar, and I'm going to give him that opportunity.
Okay.
Hi, Ms. Greenhouse. How are you today? Good to see you as always.
Thank you, Judge Morrow. Nice to see you too. Good to be here.
Thank you.
Thank you. Okay.
Mr. Ford? You're on mute. You're on mute.
My apologies, Your Honor.
No problem.
My client has decided to go with the non-negotiated of 60 days, which will give him it will give him 19 more days in jail. Your Honor.
Okay.
And go FVIP and then no further contact and to stay away.
Okay. Do you have the, can you get him the paperwork?
I can get you the paperwork. I can't get him the paperwork, but I can ask if he would give me permission to sign.
Okay, and you'll have to go over the paperwork with him, right?
Yeah, I have to go over with him.
Okay.
So if you want me to, you can put me in another breakout. I can just go over with you. I got it right here.
Okay, why don't we do this? Ms. King,
Yes, Your Honor.
I have the SCA calendar that's this afternoon. It should be relatively short. Can we have Mr. Ford fill out all this paperwork and take a plea this afternoon? Are you available this afternoon or not? If you're not, I'm just trying to, or if you want to wait now, we can do that. I want to make it as efficient as possible for everybody.
Or I can send the information to whoever will be on SCA for it to be handled then. Or would you prefer I take it, Your Honor?
No, it's however you want to do it.
So I would prefer that you take it. I would take it, Your Honor, but I have a doctor's appointment, so I'm not going to be available. So
okay.
Maybe if you want to wait or if you want to do it on the C calendar, it's up to you, but I would prefer that you take it.
I'll be okay with waiting, Your Honor, but
okay. I'm fine with waiting. I'm here, so I have nothing to do. I just want to make sure that everyone and so since we're going to do that, why don't we do this first? Why don't we go over the calendar, and then I can release everyone that we don't need at that point, and then those that we do need can stay. I just don't want to hold everyone. So can we go over the calendar now? Is that fine? Okay.
Will I be able to go into a breakout session, just go over the paperwork, Mr. Florinori?
And I can get the calendar for Mr. Ford.
Okay. Normally Mr. Ford likes to be here to go over the calendar.
I want to be here for the first part of the calendar. I definitely want to write that down.
Okay, so you do want to be here to go over the calendar, Mr.
Just
Ford.
the first half, your first 19.
Okay, all right, okay, that's fine.
Then you can move me into a breakout room with Mr. Florinori.
Okay, all right, whenever you're ready, Ms. Grace.
What happened? Can you catch me up on speed?
Oh, so just hold on for a moment. We have a 9 o'clock calendar that we have to go over, Mr. Florinori, then we'll get back to your business, okay? So just give us a few moments.
Position number 1, reset jail jury arraigned. Position number 2, reset jail jury. Position number 3 was a plea. Position number 4, reset 920 SAP. Position number 5, reset 929 competency calendar. Position number 6, reset jail jury arraigned. Position number 7, reset 920. Position number 8 was a plea. Position number 9, reset 920 SAP. Position 10 was a plea. Position 11 is reset jail jury and arraigned. Position 12 was a plea. Position 13, reset 920 SAP. Position 14, reset jail jury arraigned. Position 15, reset jail jury. Position 16, reset 920 SAP. Position 17, reset 920 SAP. Position 18, reset jail jury arraigned. Position 19 and 20 were plea. Position 21, reset 927 SAP. Position 22, reset 920, position 21, reset 927, 22 SAP. Position 22, reset 920 SAP. Position 23, reset further notice. Position 24, reset further notice. Position 25, reset 920 SAP. Position 26, reset jail jury arraigned. Position 27, reset jail jury arraigned. Position 28, reset further notice. Position 29 was a plea. Position 30 and 31 were pleas. Position 32, you said 920 SAP. Position 33 was a plea. Position 34 and 35 were pleas. Position 36 and 37 were non-class. Position 38, we said 920 SAP. Position 39 was a plea. Any questions or concerns?
No, and I apologize. I must be out of practice because I definitely didn't keep up with that. I definitely did.
I've got the latter half after 20. I've got those.
I'm worried about the first 19 or 18. And I just, because there were some different dates that were thrown in there than what I have. And so I have 920 SAP for 4. And then do I have SAP for number 5? Was it 920 or 913?
It was 929 to the competency calendar for position 5.
929, okay. And then 6 was arraigned. That's not mine. That was not mine. Then I got a plea for 8.
Yes.
And then 9.
Was a 920 reset? Is September 20 reset?
Yes.
It's 920 reset for SAP for 9.
Correct.
And then 10 was what? Again, that's not mine anyway.
Conflict attorney. And then 13 is a SAP.
11. I need number 11.
11 is reset further notice.
Okay, that's right. She did that. And
12 was a plea.
12 was a plea.
13 is a SAP reset to 920.
920. Okay. 14 was that a rain?
Reset further notice.
Yeah. All right. Then number 15, that's not
Private
mine.
attorney.
16.
16 and 17 reset to 920 SAP.
920. Okay. I didn't get those dates. I apologize. And then number 18, that's all I need.
Reset further notice.
Okay. All right. I'm good.
Okay, so we'll put you back into the breakout room with your client there. If you'd like to, for those of you, if you'd like to stay, you're welcome to. Otherwise, we'll still need Ms. Greenhouse to be with us, and everyone else is free to go.
And I just want to say, if Ms. Melissa Grace has received my package with the pleas and the bench warrant and the bond orders.
Yes, I'm missing a bond order. I have one on Robert Jackson. I think your other client was towards the end of the calendar. I'm missing that bond order.
Okay, but the bench warrant set aside is there. I'll get you the other order.
Yes. I have it.
We'll be in recess until someone comes back. Thank you all.
Good afternoon, Ms. Janice. Are you here for today's counter or the SEA counter? You're on mute.
I'm here because Lonnie Flannery asked me to speak on his behalf. That's my son. And I think he's already been before the judge.
They're in the breakout room right now he's in the breakout room with his attorney right now.
Okay.
They had called you. I do not know. Do you just want to go in the breakout room with them?
Sure.
Okay.
Mr. Ford, where are we? You're on mute, Mr. Ford.
We have filled out the plea paperwork, Your Honor, and I will have that to you. The victim in this matter joined us in the breakout session. And so I didn't know if she wanted to say anything, but I did let her know that you had already ruled and made your decision on the 60 days and the other conditions, the family violence intervention, no further contact, and maybe her conversation may sway you to do no further violent contact.
Well, I think that she has some outstanding no contact orders that that are already in place on other matters. So I don't think that I can change a no further contact because they're not supposed to be having contact because of other issues, is my understanding. Is that right, Ms. King?
That is correct, Your Honor.
Okay. Well, okay. And then I'd ask that what's your last name again? Is it Durham? Miss Durham not speak at this time. Okay. That's not going to impact the no further violent contact. I have taken my client's plea, Your Honor. If you want to do it now, we can.
Okay, let me, did you get that paperwork to Miss Grace?
I will get it to her. I mean, I haven't got any paperwork to Miss Grace yet, but I will get it to her.
Okay, if I'm going to take a plea, I'll need to have the paperwork before I take the plea, correct?
Well, no, we normally take the plea on the record and then I will send it to you.
Okay. Well, we do have a guilty plea form that
Well, this is a plea. And my client is asking asking for NOLO, Your Honor.
And I think I've already declined that request. Do we have any?
Your Honor, if you want the plea paperwork in front of you, then I will have to scan it and send it to you right now.
Okay, if you will do that, I'd appreciate that.
And Your Honor, the state's requesting that he's remanded into custody within 24 hours.
When will my release date be?
19 days from today. So we'll have to do the math on that.
Well, that's like October the 2nd.
October 2nd, I heard somebody say?
Between October the 2nd, October the 3rd, depends on what time he turned himself in.
Okay.
And you have to make sure the paper specifically says serve 19 days. If not, they will.
Well, it says on here 60 days, serve 60 days with credit for time served 11. Do you need more than that?
Well, the jail's not, normally when they turn themselves in, they normally don't give them a 2-for-1.
They what? They don't give 2-for-1. What do you mean?
I'm just saying, if you're incarcerated, Mr. Ford, sometimes they give you the credit for 2-for-1. If you're turning yourself in to serve a certain specific time, they will not give you 2-for-1. They will give you the time that you have on there and give you the credit for it. So if you don't
2 months,
19 days to serve, he's going to serve the 49, whatever it is, take 11 days from 60 days, wherever it's from there.
So we have to put in there, Your Honor, are you willing to do 30 days rather than, because that's what I talked to him about, that it was 2-for-1. He'll do 60 and he'll do 30 days.
This is the first that I'm hearing that inmates don't get 2-for-1. I've even had jury trials where I have ordered them a certain amount of time and they get 2-for-1. So this is something that's new to the court regarding.
It's new to me as well, because I thought they got 2-for-1 no matter what time when they went in. It's scanning now, Your Honor, and I just have to email it to you, okay?
just so everybody on the same page, is it 30 days or 49? Is it 2-for-1 or? just where I can already.
Miss Lewis, can you call the jail and verify what you're telling the court, please?
You want me to call the jail and ask them again what? I'm sorry.
To verify, because I'm about to take a plea that is, I'm expecting that they get 2 for 1.
I will call the record.
Thank you.
All right. If I was at work, it'd be a lot simpler, but I'm just about there, Your Honor.
Okay.
There it is. All right, just send it to you, Your Honor.
Okay, thank you. I'm sorry, Mr. Ford. Can you send that to Ms. Grace so that she can print it out? I don't have the capacity to print from my computer.
All right, I can do that. just sent that to Miss Grace as well.
Thank you.
You did receive it though, Your Honor.
Yes.
Okay, good.
So can you print that out for me, Ms. Grace, when you get it?
She has it.
Shit.
Thank you. All right, thank you. Judge, I just got the phone with records and they said, yeah, they will give him the 2 for, normally they won't do that, but they said due to the COVID stuff, they said, he just indicated to me, Mr. Sharp, he said they will give him a 2 for 1.
Okay, very good. Thank
It
you.
just need to be clarified on the paper when he's turned himself in and what time. And what, you know, give him a report to.
Okay, thank you, Ms. First.
What time do I need to turn myself in for?
Hold on, Mr.
It's best to do it before they do break shift. Don't do it during the time when they do shift. Either he does it early in the morning or do it after, I guess their shift change after 3 o'clock, 4 o'clock, 5
I
o'clock.
want today to count. I want today to count for a day. So what time I need to be there?
Okay, did they have a new shift change, Ms. Gray? The shift changed between 6:30 and 8 because they're only going 12. They're only doing 2 shifts, so he has to be there before 6:30 today.
Okay.
Okay, so he's gonna turn himself in today before 6:30.
I didn't indicate. I just did the 60 days, Your Honor, and the
what?
And this credit for time served 11. I don't know if we have to indicate anything else on the form.
Miss Grace, on the special condition form, there is information on there when to turn itself in and everything. I'll make sure that information gets done completely.
All right.
Correctly.
Thank you. Thank you so much.
Okay. So, Mr. Fennoy, if you'll raise your right hand for me. The other right hand.
That's your right.
Do you swear from the testimony you're about to give before this court through the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay. You can put your hand down. Thank you. Ms. King?
Yes, Your Honor. The terms are 12 months to serve 60 days, credit for time served 11 days with the balance probated, FVIP, no further contact, and a stay away. The stay away address is 5500 Oakley Industrial Boulevard, apartment 302, South Fulton. I'll defer to the court regarding a stay away from the entire complex or just that unit. And the no further contact is with Anaya Taylor, INIYAH. And also a victim in the other case, Janice Durham, GENICE DURHAM.
Victim in the other case. She was never a victim in no other case.
Could you spell the first name, Ms. King?
INIYAH.
Mr. Ford, that's not listed on here. Do you mind if I add
I don't have
that?
a problem with it, Your Honor. I didn't know the other because the paperwork I had just listed the one.
Okay. So again, Ms. King,
INIYAH. And last name Taylor.
Okay. And would you put just the brief facts on the record, please?
Sure, Your Honor. This offense occurred on December 30th of 2020. Officers were responding to a domestic dispute. Upon arrival, they met with Janice Durham, who stated that the defendant is her son, and he was having a physical altercation with Anaya Taylor. This event occurred in their room. Miss Durham was trying to intervene and cool it down, and she asked the victim in this case to leave the home. She did tell the officers what she observed and what she heard, and when they spoke with the victim, Miss Taylor, on the phone, she corroborated what Miss Durham told the officers at the scene. Do you need more, Your Honor?
No, you're fine. Mr. Ford?
Thank you, Your Honor. I've met with my client on the charges and the plea agreement or the plea that the judge is handing down, and he has accepted it. I have checked all the or circled all the necessary boxes, and only thing that I have to do is ask Mr. Flonore, did you gave me permission to sign for you? Am I correct? Initial.
Yeah.
But we're willing to accept the 60 days, you know, as long as he gets credit.
30 days and 19, right?
Hold on. 60 days, as long as he gets credit for 2 for 1.
And that's the understanding of the court. Okay. Anything further before I take the plea?
Nothing else, Your Honor.
Nothing from the state.
Mr. Flonore, it's my understanding that in case 20 CR 006213J, you wish to plead guilty to simple battery, family violence, simple battery, and willful obstruction of a law enforcement officer. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this afternoon?
No, sir.
You've been represented by counsel. Are you satisfied with your counsel's representation?
No, sir.
You're not?
No. I didn't know anything about hiring a counselor or attorney when I joined.
Okay. Well, Mr. Ford has represented you, and if you say no, that you are not happy with his representation, then I cannot take this plea.
Well, I am happy with his representation. I am. Man, I'm satisfied. I'm satisfied. I'm not happy. I'm satisfied though.
Okay. So let me rephrase the question. You have been represented by Mr. Ford as your attorney giving you legal advice in this matter. Are you satisfied with the legal advice that he?
Yes, I'm satisfied.
He has given you?
Yes, I'm satisfied.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury.
Yes.
Has anyone forced or coerced you to plead guilty?
No.
I will accept the guilty plea, Mr. Flonore. The sentence will be 12 months to serve 60 days, credit for time served 11 days. The balance will be probated, a family violence intervention program, no further contact with Ms. Taylor or Ms. Durham, and to stay away from the 5500 Oakland Industrial Boulevard address. I am going to waive the probation fees for you while you're on probation to help you get and stay on your feet, but you're going to have to be on probation for the entire 12 months.
So is this check in?
Once you check in with probation, they'll let you know what the schedule will be as far as when you'll need to check in. Okay.
Okay.
Let's see. Let me just make it very clear. And I want to make it also clear to Ms. Durham, who is on the line with us. It's this court's understanding that there are other matters, the criminal matters, where there are stayaways in place for Mr. Flonore and Ms. Durham. There is a stayaway in place in this case. Stayaway means that you can have no contact. Okay, you can't have contact over the phone. You can't have contact via the internet. If you do have, you can't have contact whatsoever. I want to stress that because you won't only be violating your probation if you have contact, but you'll be violating these other bonds that he's out on bond for, Ms. Durham. If you have contact with him or allow him to have contact with you, you are not doing him any favors, okay? So, and you won't be doing yourself any favors, Mr. Flonore. So while you're on probation, you're gonna have to make sure that you abide by that. Let me also just let you know that people go through things from time to time. What I don't want you to do is if you're going through something and you don't get in touch with probation, they're going to put a warrant out for you. Okay, so if you stay in contact with with the probation department, if you do your family violence intervention program, then they'll work with you. But if you just drop off the map and they can't find you, then they're gonna seek to withdraw this probation. So I encourage you to stay in touch with probation during the time that you're on probation.
Your Honor, I do have one thing. I'd like for if you could waive the fees while Mr. Lenore is on probation, and once he completes the family violence intervention program, could non-report.
Well, I've spoken of both those issues, Mr. Ford. I've already said that I waive the fees, and I've already said that he's going to be on probation the entire 12 months in that regard. Let's see. It's my understanding that Mr. Flannery is going to turn himself in by 6:30 this evening, and it's going to be the order of this court that he specifically gets 2 for 1 in regards to this matter. Okay. All right.
One more thing about the 2 for 1. The whole 19 days, right? So when I'm in there, the 19 days isn't 2 for 1 itself, is it?
Okay. 2 for 1 is something that the jail gives. That's not something that the court regulates. They normally give a 2 for 1. I'm not sure when the 2 for 1 starts, or when the 2 for 1, or when the exact date is, but you can get someone that's in the jail to let you know the specific date that you're going to be released, sir. Okay?
No, I'm saying my 60 days, right? You gave me 60 days to serve, right?
Yes.
So that's broken down for the 2 for 1, right?
Yep, it means 30 days.
Yes.
All right.
Yes.
Then you minus the 11 days that you've already done from the 30. So that's 19 actual jail days.
Okay. All right. So if we're all clear, I believe that that is unless anybody has anything else in regards to this matter.
Nothing
from the state.
Nothing from defense, Your Honor.
All right, very good. Thank you. So that concludes our calendar for today. You all have a good rest of your day. Good